801?
Yes, Lord. I'm mentioning the file in the pending SSC, Lord. But array file. Kindly list this candidate.
What is the urgency?
Urgency that will not. There are a bunch of petitions, Lord.
Bunch of petitions they are.
But some, they are working since 2021 but not getting salary, my lord, due to the publication result. Examination is held on already in August 2025. But due to the status quo order of this honorable court, result was not published.
There is no order in this case.
Up to May 2024. Yeah, I filed the application or just asking for listing of the application. They are working since 2021 but not getting salary, my lord. Some of them are out of service, my lord. They are the teachers, those who are working since 2006, appointment in 2006. Because it failed in some papers or are not able to appear in the final examination of the training examination, but by that reason they are removed or they are not getting. Just any date, in the last week or first week of May, my application will be listed.
It will be posted in July.
Before vacation, any date before vacation.
20th of July.
May I make an unlisted mentioning, Your Honor?
No.
One.
Lord, counter affidavit has been filed by the state and the report has been submitted.
In the report, we have 5 minutes.
Yes.
At 8:36 minutes, we have come to a conclusion that there was a call which was made.
Huh?
There was a call which was made during that period of time. But what is the content of the call? What was that we are unaware of? That call during that particular period was made. If minutes have page 36 minutes.
He is already convicted. Whether this call was made between main accused and him or not, that will be decided by the appellate court.
Lord, these accused came from Bihar, my lord, and they committed the murder of the deceased near his home, deceased home.
You see,
They fled in the same. They fled away in the same vehicle.
Pattern.
There was an overt act of these respondents. They have participated. They have attacked the deceased with the lathi and rod. They have confirmed whether the deceased is dead or not, and it is confirmed by the post-mortem report also, my lord, because it corroborates that there was an injury by the hard and blunt substances on the head of the deceased, and the eyewitnesses.
What is that report? Yes, state.
Yes, minutes. We have put that minutes at page 36 minutes, which my lords have. Is our counter affidavit by respondent number 1 state. The page 36 starts minutes.
Yes.
And minutes, somewhere in the middle minutes during the investigation, when Rajveer Singh of the first party was contacted, he told that on 5/7/2025 at about 17:15, he received a threatening call on his mobile number such and such from mobile number such and such, in which Ranveer Singh, son of the resident of Minutes, threatened him. On being questioned about the recording related to the incident, he said that he does not have any recording. During the questioning, the applicant told that he has never met the person who gave the threat. Ranveer Singh, after he came out of the jail, nor has he ever received any other call before this call. In this regard, the second party mobile number such and such was contacted and questioned. During the interrogation, he stated that while he was in divisional jail, a WhatsApp message was received on his family mobile number and he was abused. To verify this, his son Ranveer called him on such and such minutes at no abuse or threat was exchanged between the two during this call. He stated that this
716 number is of this Ranveer Singh.
Of his father.
Mobile number 5716
of respondent number 2, my lord, his father, Banerjee Singh.
But the call was made by Ranveer Singh.
Yes, my lord.
Ranveer Singh.
Yes, my lord. He identified himself as Ranveer Singh.
Yes, who appears for this?
I'm appearing for R2 and R3.
Yes.
In
Why
this
did you make a call?
In fact, that when I was in jail, this person, Rajveer Singh himself, who is a lawyer, I am appearing here also, as if he is a complainant also, but he is appearing himself. And he had made a call to my family and
Which there is no report after the call has been made, no WhatsApp message, no proof have been submitted by the respondent that I have called or given any WhatsApp message. If I might have done, they must have reported or they must have submitted to the IO that I have given some WhatsApp message or call. But there is nothing on the record. There is nothing on the record to show that I have called them or I have sent a WhatsApp message.
my lord, this petitioner himself has 3 criminal cases against him. He himself, and he filed an SLP against the main accused, which was dismissed. And in the similar,
Lord, how it is related to that which criminal
because
antecedents I have?
main accused is in the same
These
case.
respondents came to my home. They attacked my brother. My brother got dead over the
But there is no
spot.
There is no
I was
recording.
also injured.
There is no recording. There is
They
no
came
proof.
from Bihar. They came from Bihar in the same vehicle. There is no overt act. They have attacked the deceased as informant. With a lathi and rod.
They allegedly came by the same vehicle, but
Where is that order of Amar Singh? SLP of Amar Singh? Have you filed it? Is it on record?
My lord,
Yes, Mr. Counsel.
Yes. Yeah, I have filed a complaint, which
Which is that order in which we have dismissed the SLP of the present petitioner against bail granted to Amar Singh.
SLP number is 14115 of 2025. The main accused Amar Singh, who is alleged to have fired from the rifle, and by which bullet the deceased is said to have been has died. But I have been said that R2 and
Everything you will argue orally.
yeah.
my lord, Amar Singh bail has been already granted.
You practice here regularly or you come from outside?
No, I am here only.
You don't understand what we are asking. You are arguing that the SLP of Amar Singh is dismissed. Where is that order? You are arguing orally. We will dismiss your bail, reject your bail.
So that I understand, my lord. What I am saying is,
Then you should understand. Upon hearing the counsel for the parties, we are satisfied that the bail granted to respondent number 2 and 3 deserves to be set aside. Accordingly, the impugned order is set aside. Happy?
no, I am not happy. I am not happy. Because
But we are also not happy.
so in the High Court, it is all these aspects have been considered. That is why the bail has been granted.
Where is that order? That is what we are asking.
We will seize this.
High Court order.
We will seize your I-Pac.
But it is the
What is this?
Lordship is your.
You are arguing on the basis of some document which is not on record, and repeatedly we are asking for it. And both of you don't understand how to argue a matter.
Lordship's your Lordship's order is here.
Yes, sorry, dismissed. Yes.
Yeah.
It is set aside. The impugned order is set aside. It is also brought to our notice that the respondent number 2 and 3, who are father and son, they can account who is father, who is son.
Respondent number 2 is father.
Respondent number 2,
Who is father?
it is also brought to our notice that from the mobile number of respondent number 2, his son,
Will file it.
his son, respondent number 3, has made a threatening call to the petitioner after his release on bail under the impugned order passed by the High Court. In view of the above, we are satisfied that the respondent number 2 and 3 have not conducted themselves properly, and therefore they do not deserve to remain outside the jail, because there is apprehension that while on bail they may further threaten the petitioner and may put their life in jeopardy. Accordingly, the SLP is the appeal is allowed and the bail granted to respondent number 2 and 3 is set aside. Yes.
Grateful, my lord.
My apologies.
So-
Great.
In item 2, Lord, a reply has been filed by the
Yes.
complainant. Lordship,
Leave done.
I appeal for the complainants, Lord.
Yes.
Lord, in
Lord, your Lordship will see, your Lordship already 1st of December 25.
Yes.
So they procured the interim protection by making a statement that we are ready to execute the sale deed
Yes,
on
yes.
30th of March. Please see
That is
1st of
what-
December order. And Lord, now they don't turn up. I give them a notice, they don't turn up for sale deed.
Hmm.
This is the whole ground. Please see 1st of December order, Lord. That is the only pretext on which they sought interim protection. Please see 1st of December order. Para 2.
Hmm.
London Caesar Counsel for the petitioner submits that under the agreement to sell executed between the parties, time allowed for execution of sale deed is till 30th of March 26, and the petitioner is still ready and willing to execute the sale deed.
Hmm.
On this basis, they secured interim protection, Lord. Now please see my application, Lord. On 16th of March, I sent them a notice that please come for sale deed. They don't come. I kept waiting from 9 in the morning till 5 in the evening. They do not come. Please see my IM, Lord. 123976.
I think I have a right to open the argument first before the complaint said. Lord, we are still saying that as per the agreement, we are ready to execute.
1 week, 1 week time.
No, just one thing. Page
1
18,
week time.
Lord, page 18, just they have served with a legal notice a document which was not in my possession. Now they have placed it on record without translation.
No, we do not know. Forget about the past.
Lord, my assumption.
You executed in 1 week or
Yes,
15
Lord.
days.
Lord, for that, as Lord may say that as per the agreement, they are putting up an unsigned, a receipt for 97 lakh that they have paid me 97 lakh rupees after the agreement to sell. That document, just for a minute, may have a look. Page 18, Lord. Just for a minute.
No, as per agreement. As per agreement.
Yes, Lord, as per agreement, I am not.
Yes.
Now,
He is ready as per agreement.
yes, let him say.
Yes, Mister.
This is over and above the agreement, 97 lakh in cash. Without my
Lord,
signature.
He has signed. The receipts are there. He has signed those.
Lord, this is what I want to show, page 18, Lord. The reply, just for a
It will
moment,
be-
I can put
It
the
will be in terms of the agreement.
Yes, Lord.
Otherwise, you file a suit for state performance. Where the parties will be
And
at
my
liberty to prove
co-sharers-
their respective case.
And there are 6 co-sharers. 5 of them have been granted anticipatory bail by the High Court, Lord. Considering this fact, Lordship, we just have page 18. How this fake receipt has been prepared.
The
Lord.
dispute between the parties arise out of a sale agreement which, according to the complainant, has not been honored by the petitioner accused. Full stop. In 2025, we have granted interim protection to the petitioner. Full stop. When the matter was argued today, learned counsel for the second respondent, complainant, submitted that on 15th March 2026, he was present in the office of sub-registrar after informing the petitioner for execution of the sale deed. However, he did not appear before the office of registrar. Full stop. Countering this submission, learned counsel for the petitioner submitted that the second respondent is demanding an amount more than
No, he says that an amount of 97 has been paid to me over and above the agreement to sell. And that should be
that
adjusted.
second respondent is claiming that he has paid an amount of rupees 97 lakhs to the petitioner
Over and above 35 lakhs earnest money shown in the agreement to sell.
over and above the earnest money of
35 lakhs.
35 lakhs shown in the agreement.
Yes, Lord.
I'm disputing that.
Full stop. There appears to be a dispute as to the payment of amount at the time of execution of the agreement. Full stop. Be that as it may, the dispute between the parties can only be solved in a properly constituted suit and not in this bail petition. Full stop. At present, at present, we are satisfied that considering the dispute, the nature of dispute between the parties, the petitioner deserves to be released on anticipatory bail. Accordingly, so and so, the SLP is disposed of, directing that the petitioner shall be released on anticipatory bail in crime number so and so.
And your lordship may add that Lord, he will execute the CLD in 1 week, Lord. Your lordship observed.
You lost an
execute the
opportunity. You lost an opportunity.
CLD. Your lordship may observe, your lordship may record that statement that they will
You
within a
lost
week
an
they will.
opportunity. Mr. Council, you must understand. Now you will file a civil suit, and then this will drag on for decades.
Lord, I will not, Lord. Your lordship, they made a statement
Lost
that
a
they are ready.
golden chance of getting a CLD executed in your favor.
Lord, your lordship may say in this order that they subject to them
This
executing the
fight,
CLD. That's it, Lord.
this
In within a
fight
week, they-
judgments by this court
Yes.
about this civil dispute, money transaction. I
Lord,
do
I
it
bow down, Lord.
repeatedly
Lord,
so
please see
that
their conduct,
there is
Lord.
no multiplicity of litigation, and the parties resolve their dispute here itself.
Lord,
When
please
they
see their
don't-
conduct, Lord.
if
I
they
bow
don't
down, Lord.
seize the opportunity, what can we do?
Lord, they make a wrong statement before your lordships, and now, Lord, they are, Lord,
As a
from that
litigant
statement, Lord.
also, you should not only be a litigant, but a prudent litigant.
Lord, your lordship may kindly bound them with the
Know about
agreement, Lord.
your
At least,
rights and your, as soon as
Lord, I bow down, Lord. Please
to
see their
get that,
conduct, Lord. They make a statement before your lordship and then they resign, Lord.
both of you want that the dispute shall continue for some time.
No, Lord,
Anyway,
we don't want that, Lord. They have
for
taken
you
my
to
money,
decide,
Lord.
for
At
you to
least they
decide,
should,
you do not know.
Lord, your lordship, it fell from your lordship that they within a week they should execute. Lord, let that be recorded, Lord. It fell from your lordships, Lord. Lord, otherwise they run away with my money, Lord. They have taken anticipatory bill, they will run away.
They
So
are
please,
running away, and because of you are responsible for it now.
Lord,
He says
kindly.
he is ready. Both of you have an opportunity to go for mediation and resolve it. If it is a
Well,
matter
Lord,
of few lakhs
Lord, may I
only.
say this? Your lordship may keep it pending. We'll go for mediation here. Your lordship may keep it pending. Lord, because otherwise, Lord.
What about our fees? You don't decide between yourself. When we
Lord,
suggest something, you say yes, we'll do.
Lord, your lordship knows, Lord, once he gets anticipated bail, he will never execute the sale deed, Lord. And I have to litigate for so many years.
You must have realized this.
No, that's why I gave him a notice.
And you
I was there.
didn't utter a word when we were dictating the order. You kept quiet, as if you are happy with this order, like the earlier council.
No, Lord, I thought, Lord, I'm so sorry, Lord. I was under the impression that your
You
lordship
don't
was making them.
understand this advocacy.
Lord, I apologize, Lord.
Court is willing to accommodate, and you are not ready.
I apologize, Lord. But your lordship, it fell from your lordship that within a week they will execute the sale deed, Lord. Let that be recorded, Lord. Otherwise, Lord, they made a statement before your lordship and now they are running away from that statement, Lord. Please see their conduct, Lord.
वो SLP is disposed of ऊपर लिखे होगा पढ़ना पूरा order.
The dispute between the parties arose out of a sale agreement, which, according to the complainant, has not been honored by the petitioner accused. By order dated 1st December 2025, we have granted interim protection to the petitioner. When the matter was argued, Learned Counsel for the second respondent complainant submitted that on 15 March 2026, he was present in the office of sub-registrar after informing the petitioner for execution of the sale deed. However, he did not appear before the office of registrar. Countering this submission, Learned Counsel for the petitioner submitted that the second respondent is claiming that he is paid an amount of rupees 97 lakhs.
He has paid.
He has paid an amount of rupees 97 lakhs to the petitioner over and above the earnest money of 35 lakhs shown in the agreement. There appears to be a dispute as to the payment of amount at the time of execution of the agreement. Be that as it may, that is
Full stop. Be that as it may, काट देना. Be that as it may, काट.
Be that as it may.
हाँ वहाँ से कट कर देना. उसके बाद हम लिखा दें, है ना? There appears to be dispute between the parties. वहाँ तक लिखा है ना? Full stop. In view of the above, and as agreed by learned counsel for the parties, comma, they are referred for mediation to be conducted by the Supreme Court Mediation Center. Let the parties appear before the mediator appointed by the Supreme Court Mediation Center on 8th of May.
Not one clarification. There are 6 co-sharers who have to execute the same deed. So 5 others we have not made issue notice to them also, because they have been granted anticipatory bail by the High Court now. Because I can only sell my share, but if the entire agreement is to be executed, but then 6 persons have to execute the same. This is my
This mediation should be here or before the.
Yes, it is better if it is at the.
So
This belongs to Punjab airport.
Yes, ma'am. Yes.
Rajasthan.
If the SLP is being kept pending by my lords,
We are keeping it pending.
then my lords, it may be done.
We are keeping it
This is how the practice is.
We are keeping it pending.
Right here only, Lordship, may just say that
Let the parties are.
all the
Let the parties appear before the mediator appointed by the Supreme Court Mediation Center on 8th May.
Let the parties appear before the mediator appointed by the. It is Rajasthan High Court Mediation Center.
Supreme
Punjab.
Court.
No. This is arising from.
Punjab.
Punjab and Haryana.
This is item 2.
Yes,
Please,
my
my
lord.
Punjab.
Punjab and Haryana High Court Mediation Center. Full stop. It is in the center on 8th of May. So and so. Full stop. Since there are 5 other signatories to the sale agreement,
Co-sharers.
They are co-sharers.
Just-
Co-sharers.
oblique co-sharers to the sale agreement, comma, the petitioner shall join the co-sharer as respondents herein, and the said co-sharers shall also be involved in the process of mediation. Full stop. Post the SLP on 30th July for submission of mediator's report.
No, interim to
Highly grateful.
Interim to continue.
Grateful.
Highly
Yes.
grateful.
3. Lordship, at the time of filing the FIR, the charges against me were under section 137 of the BNSS and section 11 and 12 of the Volkswagen. Now, prosecutrix in her statement under section 160 and 164. Prosecutrix in her statement under section 160 and 164 categorically denied sexual assault or wrongdoing. Only in the supplementary statement dated 23/04/2025.
But the
the allegation-
DNA report is against you.
Your Lordship,
DNA report, FSL is against you.
Lordship,
In the salwar of the prosecutrix, your response are found.
Lordship, if we look
And
at
that
the,
is matching with your blood group.
Lordship, if we look at the entire
Even
circumstances, this
we
is
do
the
not know.
clear-cut case of consensual relationship. Your Lordship, in
No,
her-
consensual C is 16. What consensual? C is 16.
Lordship, in the similar matters, the Honorable Supreme Court only granted the bail.
There is no similar matter in bail.
Lordship,
Similar may be only when you are in jail since 5-6 years.
Lordship, I have already been in
Only
custody.
that, only on that ground there may be some similarity. Otherwise, every case is different.
Indeed, Your Lordship. Lordship, I have been in custody for 12 months and only 5 witnesses have been examined and there are 21 witnesses. And what I am saying is, in her cross-examination, she herself admitted that she was. Lordship, that the phone which she was using was provided by the accused only, and for the past 2.5 years, she was in the constant relationship with the accused.
You see, that is the usual modus operandi of all such people.
Lordship, in case of
First provide phone and then
Lordship, in fact, the session judge in his own findings has written it that she prayed before the court of law that the bail should be
Minor,
granted to the accused.
minor dismissed.
What?
The petitioner, brother-in-law,
I have to file my counter affidavit.
1 week per counter.
Allow me to join the investigation.
My lord, I am appearing on behalf of complainant in this case, my lord. Let the complainant be included as a party, my lord.
Let complainant be imputed as party respondent.
My lord, allow me to join the investigation.
Complainant. Complainant
Please, my lord.
may also file counter before the next date of hearing.
Grateful.
Say 2 weeks, post after 2 weeks, not 1 week. Why have you not joined?
My lord, because there is no order, my lord. Only arrest has been stayed.
Then
My
we'll
lord-
withdraw your interim bill.
My lord,
If you need our order to join investigation,
that I'm seeking unconditional
An-
apology, my lord.
an accused seeking a direction to allow him to participate. You should participate. You go,
I will, my lord. Tomorrow,
call him
My lords, will
and interrogate.
please.
or my lords will fix any date, my lords. After a day or two, my lords, he will appear before the IU.
Yes.
We will not fix the date.
My lords,
We will not monitor investigation. You know your statutory duties.
will do it. It's okay.
Please, Lord. Well, this is an application for anticipated bail, Your Lordship, so please to protect me, Lord. Lord, during the pendency of the matter to the Honorable High Court, I have attended, Lord, almost on 15 dates. And, Lord, after the order of Your Lordship, also, Lord, I was called on 4 dates I have attended. So my learned friend in the counter affidavit are saying, Lord, that I have not cooperated. Lord, the issue is, Lord, an agreement of registered agreement to sell was executed in January of 25. And finally, a sale deed was executed after almost a year, Lord, in November.
Yes.
Lordship, I have said in my counter that he has not cooperated because I have the instructions. He is appearing before the investigating officer, but he is not answering the questions. Also, on the last occasion, the petitioner has said.
On hearing and counsel for the parties, we are satisfied that the interim order passed by this court
I am the
on
advocate of the complainant. I presented before the High Court along with District Court. Your Honor, I may permitted to file my representation in the matter because matter what is supposed to place before the Honorable Lordship is not as such as they show. In fact, matter consists
I
of
don't follow
illegal money laundering along.
I have not followed what you are arguing. You are appearing.
Your Honor, kindly permit me.
You are appearing.
For the sake of I may get permission. I am the representative of the complainant, Your Honor, before the High Court, the District Court as well. Your Honor, I pleaded for permission to give me a chance to argue on behalf of the real controversy of the matter is not as such as they are supposed to place. It is a simple transaction.
Let complainant be joined as respondent.
Highly obliged, Your Honor. Highly
All
obliged.
parties be corrected. Complainant may file his counter affidavit before the next date of hearing, post on 14th May. Interim to continue.
Like,
My lord, I am appearing for the petitioner, my lord. Yeah, I am appearing for the petitioner. I filed an application seeking permission, my lord. At this stage, my lord, may I submit that I am praying for the issuance of a notice for the limited purpose of the mediation, because reason being, my lord, I am told by the girl that both are willing to marry for XYZ consideration. That is not happening. Panchayat was also held, my lord. And both, I am not arguing on merits at this stage. Perhaps my life will be saved, because that is my humble submission. If the mediation takes place, my lord, perhaps the matter will be resolved, my lord, and my life will be saved. I am the, because I had no opportunity to tell anything either before the session court or before the High Court. This is first time I am before my lord, my lord. So I am praying for limited purpose of mediation. Yes, I leave it to my lord, my lord.
But you are challenging the bail granted to him.
Yes, my lord. That's
You
why
can
at the outset I made the submission, my lord.
So you can marry him.
Yes, my
Who
lord.
will stop you?
My lord, Panchayat was held, I have said in my petition, my lord. And in fact, they were about to marry, but for the consideration, my lord is aware in the village, my lord, that did not take place, my lord. So unless until the boy come before your lordship or before the mediation cell, so I'm helpless. And first time I am before any court, my lord.
You want our seal to marry?
No, my lord. I am saying only let the matter be referred for the mediation, my lord. And for that purpose, I am requesting my lord to issuance of notice.
We have not opened a marriage facilitation center in Supreme Court.
My lord, then on merits,
You want to marry, you go and marry him.
My
Who
lord,
has stopped you?
My lord, that I cannot unilaterally do unless until he comes.
Sorry, dismissed.
My lord, may I submit, my lord? Kindly then have page number. Kindly have then page number. My lord, on
Yes.
merit, my lord, in 2020, the relationship took place at that point of
Yes,
time.
yes.
Minor, my lord. I am a minor girl at 2020, my lord.
Permission to file that.
My lord, may I submit? My lord, may I submit, my lord? Only one line.
Next, we have already dismissed.
My lord, only one line, my lord.
Yes.
My lord, 2020, I was only 16 years old. Page number 3 of the impugned order, my lord, and I told this fact before the magistrate when my statement was recorded, my lord. And the anticipatory bail has been granted, my lord. Page number 3 of the impugned order, only one line, my lord.
That is exactly
my lord.
That is exactly
number
the reason why anticipatory bail granted should not be confirmed.
Wait, please.
Yes, next.
The union has challenged the order granting bail only on the reason that it is not only under section 67, which the Honorable High Court is saying, but it is a prima facie case also. Now let's kindly see page 89 in our complaint, where this respondent has stayed with these accused in the hotel. We are saying it is the overall conspiracy, drug trafficking case, and she is the main conspirator. She's just been inside 7 months, and on them from those 7 months, 3 months on medical bail. Only the custody period is 4 months, and she's the main conspirator. Just see page 89 of prima facie case. May kindly have, if I may just read.
Delay.
That of course.
If you are so serious about
it, we have to come at the earliest, my lords. I bow down.
You should come always.
But this
See,
is a
52
very
days,
case.
not a delay of few weeks.
I bow down, my lords.
See, 52 days delay. And you are arguing so seriously.
My lords, NDPS cases.
Why your officers are not so serious when the bail is granted?
3.5 kg heroin, my lords.
See, you want any further comment on your officers?
No, my lords. It's a delay. I bow down, my lords.
Not delay. You are saying so seriously, you are very, very serious about 3.5 kg heroin.
You should have come earlier, man.
It should have moved your officers at that level.
You should have come earlier.
We'll impose cost to be recovered from that officer who has not filed it and issue notice. If you are ready, we'll impose cost.
We cannot do that, man.
No, while you see, we have to condone the delay. And if we condone the delay, there has to be some terms. No. Dismissed on the ground of delay.
Well, it's then an observation that in case, Malats, there is anything adverse we find against the respondent, we can come again, Malats. Because the trial is going on, and in case it is delayed or something, then we can come. Because otherwise, Malats, the bail is, in a sense, confirmed.
No, I have not followed. If the trial is delayed,
on account of the respondent not Malats coming regularly or delaying the trial, I'm just asking for that, Malats. If we can come again, if there is
seeking cancellation.
Yes.
On the ground that they are not cooperating.
The respondent, Malats.
Yes, they are respondent are not cooperating.
Yes, because the trial is now going on. So I'm only humbly requesting, because once the bail is given by this court, then
that we can't do. Because for such observation, we have to condone delay. Otherwise, we cannot consider on merits and make observation. And once we condemn the delay, then difficult.
Well, so any post conduct, I'm just saying that after the bail is granted, if there is any post conduct which comes to our notice.
Dismissed on the ground of delay. However, if the respondent does not cooperate in the trial, the petitioner would be at liberty to move before the High Court seeking cancellation of bail. Yes. Next.
Wait, please, Lord. This is a case where I beg to appeal for the complainant.
Yes.
Now, this is a case wherein the court says it's a civil dispute, and because I agreed for mediation, I'm not interested in prosecution with the greatest of respect. Mediation was sought by the other side, and whenever your lordship ask the parties to go for mediation, we never say no. Part 1. Part 2, the accused says that he was in 2023 was 62 years of age, and I, who is 65 years of age, have given him a soft loan of 1.5 crore for 20 years at the rate of 4%. Thrice the IO, twice he has gone for investigation, twice status report has been given by the IO.
Mediation has also failed.
Mediation has failed. Court says, court is taking a contrary, saying, why did you go for mediation? When your lordship will in any matter ask us to go for mediation, we will never say. And it was the accused who had sought mediation. We had to.
What is wrong in granting bail?
For the reason, kindly see the status, please status report. Continuously, this man, the first kindly see the first interrogation report at 101.
It's a money transaction.
It is a money transaction. What was there, is that I have been duped. Now, kindly see the first interrogation report at 101. Therein, he gives wrong statement, before the IO. He says, there is no criminal case pending against me. He says, I have only 2 bank accounts. In the next investigation report, he says, no, there are 2 cases, previous FIRs pending against me. He says, yes, I also have a bank account. He files a document, wherein the IO has given a report that a notarized document has been
the total amount involved.
From me, 1.5 crores, admittedly, and he says, I at 65 will give him for 20 years. I will not see the day after 20 years.
20 years?
Yes, he says so. That I, the complainant, gave him the money because he is my niece's father-in-law. That is my Sala's somebody. So he says, I gave him 1 crore of rupees for a period of 20 years to be invested. I at 60.
Sala ka samjhi, it is too complicated.
That's exactly.
Dismissed.
We kindly appreciate. I have given, there's no dispute. He's admitting the money has been given to him. He's not saying that money has not gone. It has gone by RTGS. Today, the High Court says that why did you go for mediation? Now, please see the order of the High Court. The complaint.
Sala ka samjhi, and you are not able to mediate and take it.
For the reason, he is not coming. In fact, his son has lodged an FIR against him. He is saying things against his son also. Please see the order of the High Court.
His son means your Sala.
Sala's damad.
Sala, they're complicated.
That's the problem. Kindly see the order of the High Court for a minute. What have I done? What's wrong in what I have done? Page 220.
Since it is in the family itself, there may be some mediation.
Lordship, please.
Notice.
My lord, perhaps one thing my friend
You are also
should
here.
want, I'm supporting him. But all I'm saying is, let the observations of the order, observations in the order may not be, my lords, adversely affect the rights of the case itself.
No, we have issued notice.
Oh, may I please?
Yes, we have issued notice. Yes.
Deeply obliged.
May I please?
31.
Please, Lords, I'm requesting a short accommodation in this matter, Lords. The arguing counsel is in some.
Anticipatory bail you are seeking.
Please, Lords.
What is the total amount?
Lords, Lords, it is 27 lakhs. Lords, the issue here is Frank Move involved.
You see, you first file a better typed copy of the impugn order.
Please, Lord.
Then counsel for the petitioner is permitted to place on record typed copy of the impugn order which is not legible.
Lords, I'm only requesting permission to be given to file some additional document. But other co-accused have
He
been
may
done.
also file some additional, he may also file additional documents. As per post after a week.
The petitioners are cousin father-in-law and cousin mother-in-law. She
Huh?
committed suicide. They have been
Anticipatory bail, dowry death.
Lordship. Yes, they have been living separately. There are 6 persons. The offense has been registered. They are the residents of separate and the allegations are against 6 persons. She had committed suicide, and there is also in the FIR it has been mentioned that she was in relations with another person and she used to talk with the person on phone. This is has been mentioned. The CGR calls, victim calls have also been mentioned. So far as the present petitioners are concerned, we have submitted details that they are nothing to do with that allegation. Father-in-law, not father-in-law, cousin father-in-law, and cousin mother-in-law. The High Court has only dismissed the application because earlier application was dismissed as good cause. On this reason, the High Court has dismissed it. Kindly see page 29. We have submitted the detailed documents that these persons have been living separately. There was partition in the family.
No, the deceased was living in which village?
Deceased was living in the same village, but they have been living, the house is different. The applicants are separate and no direct involvement day to day. Mediation, Panchanama, prepared certificate, Gram
So
Panchayat.
you are the mother-in-law and father-in-law.
No, my lord. Cousin mother-in-law and cousin father-in-law. Chacheri means uncle, the wife of, he is the uncle of the husband of the deceased and auntie of the husband. Mother-in-law and father-in-law, they are separate. They have also been accused. The sister-in-law has also made accused. There are 6 persons have been accused. And the allegation is this: a motorbike was demanded, and there was a demand of
What is the allegation against you?
Omnibus that a demand of dowry was made. And kindly see the FIR. This fact has been mentioned that she was in continuous contact with another person. She had also talking with him. Rahul Yadav, phase 20. Rahul Yadav, phase
20.
Lordship, phase 20. Okay, this is FIR. The name of suspected Rahul Yadav was mentioned along with mobile numbers whose CDRs was obtained from cyber cells. On verification, the mobile subscriber was found to be Rahul Yadav, son of Sundar Yadav, aged about 19 years, resident of village Bhav, district Faizabad. Thereafter, a team was dispatched from police station. Suspected Rahul Yadav stated that he had conversations with deceased Sudha Lodhe on mobile number WhatsApp, Telegram, WhatsApp, Instagram, and SafeChat prior to marriage as well as after his marriage. He also stated that deceased Sudha Lodhe had informed him that her husband Viren Sodhi had an affair with another girl. This is the allegation against husband. There is no allegation against the present petitioner. Thereafter, there are simple omnibus allegations that in demand of transportation. This is only. Never had face-to-face interaction. Her husband, Biren Singh Lodhi, had an affair with another.
Petitioners are the uncle-in-law and aunt-in-law of deceased. What is her name?
Sudha.
Sudha. This is Sudha Lodhi. Who committed suicide on 20th on 20th September 2025. Stop. Considering the content of the FIR, we are inclined to issue notice to the respondent and direct the petitioner's release on entering bail in crime number so and so. PS so and so. We are we are inclined to issue notice. We can
Yes, Worship.
issue notice and grant interim bail. Post the matter on during partial working days. Yes, next.
An application for regular bail, my lord.
302.
Please.
You got hold of the deceased.
No, not the deceased. But my lord,
You got hold of the deceased.
my lord, not the deceased, my lord. There are two victims here. I thought there's one deceased, not the deceased. The allegation is that I exhorted the co-accused to fire the shot. But if I can only submit for your lordships, the High Court says that there is no change in circumstance because we withdrew the first bail application. In fact, we came back to the High Court, my lord, almost 2 years later. I was on interim bail. And my lord,
it's a notice to the respondent.
I'm late.
I appear to accept on to the behalf of the
Mr.
state.
So and so and counsel appears an access notice for respondent state of Haryana. Let counter affidavit be filed in 6 weeks. Post the matter during partial working days.
My lord, we were only one other request, my lord. His sister is getting married on the 27th, my lord, of this month. If your lordships can call for their in such a manner that I can attend the marriage of the sister, I'll be very grateful to you, lord.
27th
Of April.
Not possible.
My lord, if your lordships will, I'll be most grateful, my lord. It will enable him to fulfill his duties as a.
Yes.
And
3 weeks. बाकी हो गया ना complete?
So I'll straight come to the point. The objection on maintainability of Article 32 can never be tested as an abstract proposition of law. Maintainability of any proceedings necessarily depend upon the facts of each case. In some cases, it may be maintainable. In some, it may not be maintainable. Therefore, my lord, some facts would be relevant. But please come to writ petition 16 of 2026.
Well, once again, with great respect, I'm an officer of the court, and the highest regard for your lordships. We are on maintainability. And all submissions advanced by respondents' counsels have only been on maintainability, not factual parameters.
He's arguing on maintainability.
Yes,
I am
only
arguing on maintainability,
and
but
facts.
I am
my
not
lords. Please
delivering.
get started on facts.
I am not delivering a lecture on maintainability in general.
My friend is using your lordship's proceedings as a social media weapon in a political campaign. My lords knows this. My lords knows this.
We saw it.
Lord, it is.
Your lordship must be disappointed by
I am not disappointed. Now sit down.
Your lordship,
Now,
don't talk to me like that. I'm not your underling. Do not talk to me like that in a courtroom again.
This is not the way.
No, how can he say
She
this, my
talks to every law officer like this.
How can he? How
This
can he
is
say this?
increasing. But
How
Lord,
can he say
again,
this? Just sit down.
again, my
Does he
responding
talk
would
like
not
this too?
glorify
Is he allowed to
the
talk
behavior,
like this?
and therefore,
He
Lord,
uses proceedings in your lordship's court on social media, and a major political party posts it.
it is posted because you compared your
How
government.
your lordship's
This is
court
not
is abused. I did not compare this to anything.
Yes, be confined to the submissions.
But I am
only.
submitting, but now
And
nobody will
please
interfere.
don't abuse the proceedings in this court as a tool to be used on social
Now
media.
you can use it. I have
A
nothing
tool
to do
to
with
be used
politics.
on social media. You don't have anything to do with politics.
But
You don't have anything to do with
never
politics.
ever compare in a
Please.
democratic country
Yes.
with anyone, either
If
as a
you-
crown
if
or as
you
a queen.
understood what
Otherwise, I
extent
object to.
I was talking to a
What is this?
pre-constitutional position. The only persons behaving like the crown is you. You behave like an unelected crown and a monarch. And do not ask another lawyer.
Lord, a very dignified silence can be the only answer to this kind of behavior. Let us start with
Be
the.
silent then.
Let us start with the matter that I cannot behave like a strict fighter.
My
Can we
lord,
come to
either
page
he is
one?
dignified or he is silent.
Page one
He is
now,
neither
please
of those.
allow me.
He is neither of those. That's the problem.
Lord,
You
Lord,
please continue.
he has to prove something somewhere, my lord. I have nothing.
Only person proving is you, Mr.
yes.
Mehta. You don't have the legal arguments. You turn to
Mr.
social
Swami,
media.
take your seat. Let it.
Grateful,
let
my
it-
lord.
let
I'm always happy to appear before your lordship. Your lordship knows this.
Why do you compare the word inside the court and outside the court?
My lords, what is
Lord,
inside your
any
lordship's court
facts with
is supposed to have
beginning
sanctity.
of another argument.
Your lordship's
No, the word-
proceedings are
word-
supposed to have sanctity.
There is
The Solicitor General cannot say sit
You see,
down
the whole-
to an opposing
The
counsel.
whole
I'm sorry.
difficulty is that we try to hear the arguments silently.
well. Let me start. Let me start in my the way she wants.
Because the whole
If-
difficulty
I-
is that we can't stop the media. And once we start saying anything,
Yes.
Yes.
then it is picked up. Now it is,
Nobody can
Please
control
circulate,
it.
my lord.
it is live.
Please circulate.
It is live.
Please circulate.
Either party uses this and that
Yes,
is the
please circulate, my lord.
at times it becomes
I am
difficult
not
for us
please,
Yes,
anyway,
whether to
I
say
not-
anything in
Yes,
court
my
or
lord.
not.
But
Your
anything
lordship would
further,
have this either
anything further
follow
to
me.
encourage this
I
kind
have
of
ruled
behavior.
so many
the lordship may.
other matters before your lordships. I know your lordships is pained by how this courtroom's proceedings are being used, but that is what they're doing.
Please proceed.
Yes, madam. I would like to cite, Lord, first Rigved. Have you got? No, it's not there. Then I'll come to my Lord Chandogya Upanishad. You have? It's again not there.
What is that? Chandogya.
Chandogya Upanishad.
Chandogya.
Yes, Lord. Then I'll come to Lord. I'll go historically, and thereafter your lordship did not write.
No, this
I'll come
during
to 1919, Lord, 1915 Government of India Act. But that again, my friends have not got.
this Upanishad I am coming across for the first time.
Yes, my lord. I also came across for the first time.
Yes, yes.
Then I'll come to 1915 Government of India Act. Then I'll come to 1935 Government of India Act. Then I'll come to 1947 Indian Independence Act. Then I'll come to the Constituent Assembly debates. Then Sirvai. But they felt that that's absolutely irrelevant, so they have not brought it. And I agree with them. Therefore, now I come with the effects of this.
You are giving it in the same coin.
No, I am not giving anything to anyone. My lord. I choose my lord, friends and foes. Please have a look.
Mr. Mehta, Mr. Mehta, some of your friends should be supplied a soft copy. That's all.
Yes, no, they have not brought. I am not citing. I am not
All
citing. Don't worry.
No difficulty. No difficulty.
Lord, kindly come to page 1. Lord, this is not, my lord, a general debate on 32 and how 32 is maintainable. 32 is always based upon the fact-specific situation. Page 1 of the writ petition. Lord, that is 16 of 2026. I understand the pain of the respondents that they would not like your lordships to see some of the facts based upon which I would show. This is why 32 is maintainable. It's really embarrassing to face these facts, my lord. And therefore, I do understand, Lord, what is the pain. But still, it is my duty, my lord, to bring to your lordship's notice to substantiate my contention that Article 32 petition is maintained. Now, my lord, let us have come to page 1. Lord, kindly see, there are two petitioners. Lord, everything was argued that ED is not a statutory body, ED is not a person, ED is not a citizen, ED is not this, ED is not that. Correct, my lords? Without being told, that your lordships were never told
that petitioner number 2 is my lord Robin Bansal, Deputy Director, HUV, my lord, that is Head Unit, Directorate of Enforcement, having office at so and so, so and so. Correct, my lords?
Yes.
Now, at this stage, my lord, please also have a look at the second petition, which Mr. Raju will be arguing, my lord.
Second petition.
And we will be confining to the facts of the case, my lord, not a general discussion, my lord, on the contours of Article 32. Whatever is relevant for the present case, I'll present it. And please, we have the list. Lord, kindly just see the names and I'll connect, my lord, how their fundamental rights are violated and what are the averments made in the petition.
The second one?
Second.
Nishant Kumar.
Yes, that, my lord, the writ petition 17 of 2026.
Yes.
Nishant Kumar, son of Devi Ram so and so, working as Assistant Director, Directorate of Enforcement. Then Vikram Ehlavat. Please mark, I'm sorry, page 1. Vikram Ehlavat, son of Rampal Singh, aged so and so, currently working as Assistant Director. Then Prashant Chandania. Please, my lord, just bear, my lord, these names in mind. Something turns on that, my lord. They are before your lordships. He is Assistant Director, Directorate of Enforcement. Then, my lord, respondents are same. One is State of West Bengal. 2 is the Honorable Chief Minister. 3 is the Director General of Police, the then Director General of Police. My lord, now he is member of Rajya Sabha. 4 is, my lord, the Police Commissioner. 5 is, my lord, DCP. And 6 is the Central Bureau of Investigation. Now, please come to para 5 of my petition, my lord. Para 5.
The first petition.
Yes, first petition. How, my lord, this started? Lord, ultimately, my submission is going to be that there is complete and total failure of law and order situation in the state of West Bengal. This is my legal submission, whether someone may like it or not like it. Rule of law is a part of Article 14, which is a fundamental right, and I will demonstrate how that rule is violated, which makes the petition maintainable. It's not a political platform. I am not, my lord, trying to, my lord, please anyone, and therefore I'll confine to the legal submission. Para 5. During investigation, Lord, kindly note one aspect. Lord, this is the investigation which we are doing under the orders of the Honorable Supreme Court. But one of the investigation, Lord, which I'll refer to. Yes. Lord, here, this is a case where there is an illegal smuggling of coal from the central government's coal refineries, and the total amount runs into some 2,000 crores. 2,700 crores. And we, the ED and their individual officers who are also citizens of India, and they are discharging their statutory functions, they are before your lordship, giving these facts to your lordship and seeking my lord's protection for protecting their fundamental rights. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold to Shakambari group of companies. On analysis of documents seized from premises of so-and-so, it revealed that Maji Group used to receive cash from Shakambari Group against sale of illegal excavated coal. Shakambari Group companies are primarily into steel manufacturing. The group is led by so-and-so. Then kindly come to para 7. Further investigation regarding the utilization of POC, means proceeds of crime. This ought to have been pointed out to your lordship when I mentioned 32. Because 32 can never be decided as an isolated, abstract legal proposition. Dr. Ambedkar never conceived of this situation. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international Hawala. One such Hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so, accountant of so-and-so. Hawala firm name so-and-so was used for Hawala transfers by the coal syndicate as seen from WhatsApp chat dated so-and-so between Neeraj Singh and Ashok Kumar Mishra. Then 9. Material evidence have been gathered which discloses 20 crores of proceeds of crime arising from the illegal coal mining were used through interstate Hawala networks layered through a chain of facilitators, converted into cash at Goa and channeled into, please mark this, my lord, I-Pac. The raid in question was on this, my lord, based upon the chain of investigations and the material gathered. And I-Pac, my lord, is operational framework by being handed over to persons executing the work. Now, my lord, may kindly closely read para-10. Thus, the such proceedings were started at 10 different premises situated in Delhi and Calcutta on 8/1/26. Out of the said 10 premises, one of the premises was the residence of Mr. Pratik Jain, situated at so-and-so Malik Bazar, Park Street area, Kolkata. Please mark this name, Sri Prashant Chandalia. My lord, he is petitioner number 3 in the second petition which Mr. Raju is, Lord, assisting your lordships with. Assistant director was authorized by Sri Robin Bansal, my lord, petitioner number 2 in the present matter. Deputy director with the authorization number dated so-and-so to carry out search and seizure proceedings at the said residential premises of Mr. Pratik Jain. My lord, we have placed on record the authorization letter. They were not Tom, Dick and Harry who entered, which required, my lord, the respondent number 2, the Honorable Chief Minister, to barge in and, my lord, collect the evidence which I'll show and my lord, snatch the evidence which I'll show. Then 11. During the course search proceedings at the office premises of Messrs. I-Pac Consulting Private Limited and residential premises of Mr. Pratik Jain, certain police personnel had arrived at their respective premises and asked the officers conducting the search to intimate local police station if they wanted to continue this search. During the course of search at the residential premises of Mr. So-and-so situated at so-and-so. Now, my lord, this is residence. Earlier was the office premises. Various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of search at around 11:15 a.m., Sri Priyo Brato, IPS, Deputy Commissioner of Police, South Kolkata, visited the building premises. Now, let's see the power of this man, my lord, who is guilty, at least prima facie, of having, my lord, been a part of this Hawala network of 20 crores. The Deputy Commissioner of Police comes, South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and search authorization letter. This is what, my lord, is not in dispute. Thereafter, Sri Manoj Kumar Verma, the Commissioner of Police, Kolkata, also entered the premises. As the police officers were being briefed about the search proceedings under Section 17 of PMLA at around 12:15 p.m. This is an admitted fact, admitted by the Honorable Chief Minister in an affidavit filed before your lordship. I'll show. PM, so-and-so, identified, entered the premises despite making categorical requests for not interfering with the ongoing search proceedings under PMLA. However, violating all law and order, Miss So-and-so, with the aid of police, forcibly took possession of all digital devices and key incriminating documents from the possession of the authorized officer, Mr. Prashant Chandalia, Assistant Director, and left the premises at about 2015.
He is one of the petitioners.
He is one of the petitioners.
Prashant Chandra.
And he is now, Calcutta West Bengal police has registered a case against him. I'll show that. Those FIRs are under challenge, and we are saying, my lord, and I'll say something further, that now direct in the entire investigation to be conducted by a neutral agency. Well, all the proceedings have been recorded in Panchanama duly drawn at the premises on 8th January 26. An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. True copy of the Panchanama. Please see, my lord, now 13. It is further submitted that another premises out of the 10 premises searched by the directorate on 8th January 26 was the office premises of I-Pac Consultancy Private Limited, situated at so-and-so, West Bengal. Sri Vikram Ahlawat, my lord, is petitioner number 2 in Mr. Petition, where my learned colleague would be assisting your lordship. Assistant Director was authorized by Sri Robin Bansal, Deputy Director, petitioner number 2, my lord, of this petition, with the authorization number so-and-so, dated so-and-so, to carry out search and seizure proceedings at the said office premises of Messrs. I-Pac under section 17, and proceedings of the said search and seizure operation were recorded in Panchanama dated so-and-so drawn at the above mentioned office premises of Messrs. I-Pac. However, the officers of Enforcement Directorate were not allowed to perform their lawful duties and were obstructed to carry out the same. Hence, an incident report dated so-and-so is drawn. Now, my lord, what is that incident report? Please come to page 79. Page 79, my lord, contemporaneous report. It starts at page 77 in presence of independent panchas. And my lord, I'll just read the relevant part at page 79. Complete absence of rule of law, and I say that because rule of law is a part of Article 14. Article 14 is a fundamental right, and I can maintain a 32 petition, my lord. Meanwhile, during the search, the Honorable Chief Minister so-and-so, Miss so-and-so, Srimati so-and-so, along with West Bengal state authorities and several senior-most police officers entered the premises around 12:40 p.m. So 12:15 is at residence, when 12:50, the Honorable 40, the Honorable CM comes at the residence office premises. During the search proceedings,
This you are reading 79.
79. I'll read, my lord, the third unnumbered paragraph.
Yes.
Lord, 12:10, the Honorable Chief Minister left the residence. 12:15, I'm sorry. And at 12:40, Lord, she, along with, my lord, about 100 police officials, DG, and I'll show, my lord, the DG was there, police commissioner was there, several DCPs were there. They come, my lord, now to the office premises. During the, my lord, meanwhile, during the search, the Honorable Chief so-and-so, along with West Bengal state authorities and several senior-most police officers, entered the premises around 12:40 p.m. During the search proceedings, the aforementioned state authorities, police officers took away the documents collected and indexed by the ED officers. Moreover, the backup of the computer system and email Ishan Taneja and so-and-so of Ishan Taneja was also stopped midway, and the state security officers took away the said computer system of Sri Ishan Taneja. The storage device of the security cameras installed in the premises was also taken in possession by the state security police officers. The state security police officers also took away mobile phones of employees of I-Pac. Please see. The person who was under investigation, who was being raided, and who was a part of the criminal syndicate, according to our investigation, my lord, is being protected at that level in this manner. I-Pac Consultancy Private Limited present at the premises. Now, my lord, coming back to para 9, page 9, sorry, para 4. Para 14, your lordship gets to know.
Yes.
It has also come to the knowledge of the petitioner herein that several FIRs have been registered in a malicious manner, targeting officers of the Directorate of Enforcement only for carrying out their official functions under the PMLA and to criminally intimidate them. Some of these FIRs that the petitioners are presently aware of are as under. We were not having copies, my lord, of these FIRs, which we got subsequently, and we have filed, my lord, by way of additional documents. The moment we get, your lordship right now need not go into. There is no, they have said officers of the PMLA. But officers of the PMLA means those who are authorized in writing and who are on the site, who are before your lordships. Now please come to my lord, para 17. Now, my lord, we approach the Honorable High Court by way of a petition. Page 11, para 17.
Yes.
Before the matter could be taken up, an entire crowd and ruckus was orchestrated inside the court through a WhatsApp group by supporters and sympathizers of ruling party in West Bengal, whose chief minister had earlier obstructed free and fair investigation by ED in the offense of money laundering and has forcibly taken possession of digital devices and incriminating documents from the search premises, compelling the ED to approach the Honorable High Court by way of present writ petition. My lord, thereafter, the true copy of the screenshot showing that the ruckus was orchestrated inside the court through a WhatsApp group is annexed herewith. My lord, WhatsApp group of the party in power. And therefore, the court passes the order which is on next page, page 12. This is what the Honorable Learned Single Judge says. The matter is taken up, my lord, in the quoted part, my lord Justice Anjari against me. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. Several requests made by the court to maintain the decorum and dignity of the court so that the matter can be taken up for consideration fell on deaf ears. This is not my submission or my assertion. The Honorable Judge records it. The environment in the courtroom is not conducive to commence or continue with.
How do you correlate to this maintainability?
One of their ground is that go there. One of their ground is go to that. Alternate. And I do not wish to, I do not like to create an unpleasant situation. On the next day, there was a hearing. The Chief Justice of India had to pass some orders. The Chief Justice of the High Court had to pass some orders where, my lord, some derogatory words were used against my learned friend and made viral. But, my lord, we are immune from that. Law officers are supposed to be immune, and any response from us dignifies something, my lord, which is abhorrent. I leave it at that. Now, kindly come to, my lord, page 15. Yes, page 15, my lord.
You just read para 18.
Yeah, yes. No, I read. Yes, para 18, the order of the para 18 and, my lord, 20. 20, I have quoted 20. That we did approach the High Court. It's not as if we have rushed here. The High Court records that it's not conducive to a fair hearing. We cannot start or continue the proceedings.
The order is at 121.
And thereafter, my lord, I'll again show, my lord, what happens when
This we have referred while receiving notice.
Absolutely, my lord. Your lordships have virtually said that these arguments of Article 32 not maintainable is virtually, my lord, decided after hearing them. But nonetheless, my lord, they
We have not decided. That was only a
prima facie. I bow down.
Since we are taking cognizance of the petition, there has to be some
Yes, my lord.
satisfaction.
But my lord, the attempt is that the facts are so embarrassing that don't go into 32. Therefore, Dr. Ambedkar, Mr. Sirvai, this, that, and others. But I am only on facts. Now, please see page 15. Because during the search on 8/1/26, the facts of this case are embarrassing, and therefore they are relying upon the great Dr. Ambedkar. But if the great Dr. Ambedkar, hypothetically, I always say, please, ma'am, Mr. Please sit down. Please, I'm requesting you to sit down.
Why
Please.
should you request me to do anything?
Please.
I'm in my lord's courtroom.
But
Why should you request me to do anything? I mean, since you got in Dr. Ambedkar.
My 119. Before I come to page 15. One one nine. My lord, the WhatsApp message, my lord, which I have.
We are off the track in this.
Huh?
Yes, please.
We're discussing something else.
Yes, yes.
Yes, sir. Obviously, my lords were discussing something.
119.
Yes.
Legal minds.
Yes. Lord, I am in position of a Mahabharata scene. 119, Lord. Please have a notice. Today, 9/1/26, court number 5, item number 10. Come, everyone. Lord, he is, my lord, so and so, convener High Court, my lord, of that particular political party. Gathering today at 1 p.m. at B gate. Come, everyone. We'll go to procession of Honorable CM. Bus and vehicles are arranged. Read it with the order of the learned single judge that not only lawyers, others have also come, and it has become completely impossible to conduct the proceedings.
No, this is inviting for this procession of CM or in the court?
No, both. In the morning, come to the court, and 1 o'clock, buses are arranged. We will have to go to CM's rally. That's the.
It is two parts, para 1, para 2.
He is the lawyer and politician both. So he is discharging both the functions, and when we do that, difficulty arises. Now, page 50. Para H. Because during the search on 8/1/26, which was being conducted peacefully and in a lawful manner until the Chief Minister of West so-and-so, along with the DG Police, West Bengal and Calcutta Police Commissioner, and a force of about 100 policemen barged into by committing criminal house trespass at the residence of Pratik Jain, where the search was going on, and illegally committed theft and forcibly took away documents which were taken in possession by the ED officials conducting the search. The following conducts, my lord, we have said what are the offences, my lord, which are made out. Now, please come to, my lord. This is not, my lord, an isolated case that we rush before your lordships. Lord, this can be brushed aside as an isolated case. Lord, I have made out a case that in the state of West Bengal, Lord, such a beautiful state, Lord, considered to be the cultural capital of this country, Lord, what is the position, my lord, it has been brought to, and that is what I want to show. There is a pattern of complete breach of rule of law, my lord, that your lordships would find at page 19. This is not an isolated first of its kind incident. Well, the Honorable CM barges into an investigation is thwarted. Investigation by the lawful authorities are thwarted. Para, Lord, Roman 6. It is submitted that the CBI is conducting an investigation under the judicial orders passed by this honorable court. Lord, we are an extended limb of this honorable court in this particular case. In pursuance, the said, I am talking about now CBI, what they faced. in pursuance to the said investigation, the team of CBI officials, my Lord Justice Anjari, page 19. Page 19, Roman 6.
Roman 6.
Just to show that this is a pattern.
Yes.
And therefore, I have made averments that please take cognizance.
This is some other investigation.
Investigation.
Not
Yeah,
this
some
investigation.
other investigation by the CBI. But modus operandi same, individuals involved same, and the pattern is same. To show that present incident is not a standalone, isolated case. It is a pattern. The rule of law is the rule. Absence of rule of law is the rule. Lord, page 19, first sentence. The present incident for which prayer is made for registration of FIR and investigation by CBI is not a solitary incident of such nature wherein the respondent number 2, the Honorable Chief Minister, has misused the state machinery to criminally intimidate officers investigating serious offences against her or her party members. It is submitted that it is a matter of record of the court proceedings that the respondent number 2, the Honorable Chief Minister, has made a pattern to take law into her hands and misuse the state police wherever, whenever any crime is investigated which is not of her liking. Then, my Lord, next para. It is submitted that CBI was and is conducting an investigation under the judicial orders passed by this Honorable Court. In pursuance to the said investigation, the team of CBI officials wanted to visit the then police commissioner. Lord, the then police commissioner in the present case was the Director General of Police. Was. Now, Lord, he is a member of Rajya Sabha from, Lord, the same party, few days back. Shockingly, respondent number 2, that is the Honorable CM, came with a huge police force and sat down at the main gate of the residence of the police commissioner. The CBI officers were arrested by the local police and were taken to nearby police station and intimidated. It is again a matter of record that neither the police commissioner was permitted to be interrogated on that day, nor his premises was permitted to be searched. In yet another shocking incident, this is not a this is a pattern, not an isolated case. In yet another shocking incident, the respondent number 2, the Honorable Chief Minister, barged into the regional office of the CBI along with heavy police deployment and a large crowd which was constantly pelting stones at the office of the CBI office at Calcutta. Simultaneously, a large crowd, I'll read the affidavit of the Joint Director. In that case, what he faced in this case, please have a look. Simultaneously, a large crowd was sent at the residence of the Joint Director CBI. The crowd gathered and started thumping the door and window violently to get it open. The Joint Director had to frantically make telephone calls to save himself and his family. It was only after the central forces reached to his rescue that he was rescued. Lord, at this stage, Lord, please have a look at his affidavit which was filed in different proceedings, but regarding this particular incident, my Lord. Please have a look at, my Lord, the affidavit, my Lord. Lord, IA, my Lord, there is an additional document filed long back, IA, my Lord, 65087. And look at the agony he went through along with his family members.
IA 6508. Yeah.
6508.
But this is on 32, that when there is a repeated failure, a pattern of failure of law and order at the hands of those who are supposed to maintain it, protect it, and respect it. Lord, 32 is a duty, it's not just a right. Lord, that's the judgment, Lord, your lordships have said. And I'm going to rely upon that judgment. Lord, here, this is the incident where the CBI officers were arrested by the local police. They went to interrogate the police commissioner. Now, Lord, what happens to the Joint Director stationed at Calcutta, Joint Director of CBI at Calcutta, page 97. Lord, one Partha Mukherjee. Kindly, Lord, bear in mind, nothing turns on that. Just to, Lord, page 97. Lord, this is an affidavit which starts at page 96. Affidavit of Pankaj Kumar Srivastav, Joint Director, Kolkata. In that case, Lord, I'm just showing, Lord, what is the level of, Lord, failure of rule of law. And rule of law is a part of Article 14. Para 3, Lord, at page 97. I state and submit that as soon as I was given the said information by Sri Partha Mukherjee, so he's SPCBI stationed at Lord Calcutta, that our people are arrested and the crowd is coming to you with police force. I closed the doors and the curtains of my house. Your Lord, my Lord Justice Nanjari against of my house. I state and submit that by the time we could close the doors and curtains, the police personnel of Calcutta Police had already reached my residence. I state and submit that the police personnel at first started banging at the main door of my house, and soon the sounds of their shouts of their wireless sets could be heard from outside my house. I state and submit that I immediately telephonically informed my seniors in CBI head office in New Delhi and requested them to contact the union government and ask the officials to urgently approach the Honorable Supreme Court, as I, along with my family, was in complete state of lockdown. I state and submit that due to the siege and lockdown of my house at the instance of Calcutta Police, I was unable to move out and check the security and safety of my officers and the offices of CBI. My wife and daughter were terrified with the menacing shouts of the police personnel outside. I state and submit that police personnel kept banging on the main door of my house and kept shouting from the outside the house. I state and submit that the said siege of my house, under the aforementioned circumstances, with clear intent to harass, intimidate, threaten me, and to apprehend me, continued on for more than 2.5 hours in total. I state and submit that in light of the above-mentioned facts, the assertion that the police personnel gathered around my house for security purpose is an attempt to obfuscate. Then, Lord, para 4 is important. I state and submit that fearing the security and well-being of CBI officers and my family, I made attempts to contact the Chief Secretary of West Bengal, but could not reach him over the telephone. I state and submit that while the above-mentioned siege was going on, I received a few phone calls from journalists who informed me that they were not being allowed to come closer to my residence at Nizam Palace complex by the Kolkata police. I state and submit that I narrated the ongoing incidents to the media on the telephone, which was live telecast nationally. The joint director in siege talking to journalists on phone and the media telecasting it. Narrated the ongoing incidents to the media on the telephone. I state and submit that my conversion with the social media personnel was purportedly telecast on national television. I confirmed the said fact after the incident was over. I state that it was only around 9 p.m., that is after the telephone call had been telecast nationally and the CRPF had reached the Nizam Palace complex, that the police personnel of Calcutta Police withdrew from the blatant siege of my house. My Lord, when your lordships are on this, please also see the affidavit, my Lord, of the person who went for interrogation, my Lord, that is Mr. Tathagat Vardhan, DYSP, which is at page 90.
Now, what happened after this? This affidavit was filed in that.
In some other proceedings, my Lord.
What happened?
We wanted, my Lord, the interrogation of the then police commissioner who became DG now, and now he is a member of parliament. We were permitted, my Lord, to have his interrogation, but still, my Lord, the whatever, my Lord, what destruction had happened. Now, my Lord, please see.
This reputation was also under 32.
No, this was a petition filed by somebody wherein we were directed to investigate. We were respondents. We were directed to investigate. So we were directed, and therefore we were carrying out the directions of the court.
This was in some contempt petition.
Yes. So we filed a contempt petition. I'm just pointing this out that these are contemporaneous facts. And my Lord, I'm not reading, my Lord, but this police,
This incident is contemporaneous or very
No, 2 years.
2019. 2019.
2019.
19.
Not the visuals are
Stating submitted on
second paragraph.
Yes.
not visuals are shocking and embarrassing as citizens. When the Honorable Chief Minister thereafter sat on a dharna, the uniformed police officer sat with her on dharna. IPS officials. Lord, I have got the photograph. I'll leave it for your Lordship's consideration. I don't want to sensationalize. The photographs are on record, but they are black and white. Lord, I have procured the colored photograph. Kindly, Lord, see at your Lordship's leisure. This was the position. And Lord, it was being live telecast. I have heard it. That joint director is asking for help and nobody is going there. Ultimately, my lord, the Home Secretary had to send the Central Police Force to rescue the family.
This was the 2019 incident.
Yes. My lord, then there is another incident. Please come to page 20. Another incident.
Yes. Page?
Page 20
of the writ petition.
Yes. Para Roman 8, writ petition.
Yes.
In yet another case, another case, not this case which I narrated. Yet another case of hearing of a bail petition of a sitting minister, your lordship gets it.
Yes.
In the cabinet of the Honorable Chief Minister, who was guilty of serious offences being investigated by the CBI under the orders of this court, the sitting CM with a crowd, it should be sitting law minister. It's a mistake. I appeared, I am aware. Kindly allow me to correct. It's not. CM went to the office. Law minister came to the court. Not only court room where the hearing was going on. Law minister with a crowd of about 5,000 people entered the court premises. The sitting chief minister and the crowd remained in the courtroom, again law minister, itself creating an intimidating atmosphere for the judge to decide impartially. These facts are also brought to the notice of Calcutta High Court, but nothing has happened so far.
But the law minister was there to maintain law and order.
My lord, their stand is here, my lord, when we asked that when the chief minister barged in the present case, what was DG and police commissioner doing? Their answer on affidavit is that she is a Z category protectee. So we were there to give her protection, as if the Director General of Police is a personal PSO of the chief minister and he is not supposed to do any policing work and be with the chief minister. I'll come to that. Then, my lord, Roman 10. Such FIRs have manifold ulterior motives. The first is to intimidate the officers, to deter them from conducting any investigation in the present or in future. In the instant case, under the guise of FIR, please note this, in the instant case, now I'm coming back to the instant case, West Bengal police took away CCTV camera which has captured the unlawful activities of Honorable Chief Minister. When she entered, with whom she entered, how many police force was there? There were CCTV cameras, my lord. But they said they have registered cases against me, and as a part of that investigation, they removed the CCTV cameras and took it as, my lord, case custody. This is also an offence of destroying the evidence under the garb of investigation. Now, your lordships may kindly come to Lord para 21, page 21, para 21. Lord, kindly come to 23 instead. And when your lordships are examining whether to exercise or permit me to invoke the fundamental right under 30, 32 itself is a fundamental right. So your lordships would also examine at whose behest, my lord, the PMLA authorities are acting. Lord, I'll come to that, my lord. Please come to page 23. This is the ground I have given for asserting, my lord, that I have a right, the officers of the ED and ED as an institution to protect its own security and security of police officers in a representative capacity can come before your lordships. Para 23, para Roman 2. To protect the fundamental rights of victims of a large-scale economic offense of money laundering arising out of systematic illegal mining in the state of West Bengal, wherein the proceeds of crime amounting to a staggering rupees 2,742 crores generated from plundering of natural resources and public revenues, and the offense requires a free and fair investigation, which is a facet of Article 14 and 21. ED is acting as parent patriarch, is also filing this petition as a guardian and rights and interest of citizens who are unable to protect themselves, particularly in case of this nature involving large-scale economic fraud, loss to public exchequer, exploitation of natural resources, and where the victims are diffused, unorganized, and unidentified, being citizens of India, who are the ultimate owners of the natural resources of the country in view of public trust doctrine. The ED seeks enforcement of positive obligations upon the state to protect the fundamental rights of citizens from systematic economic crimes being committed with the shelter of highest functionaries of the state of West Bengal, and instead of providing assistance to the ED to unearth the crime, the sitting chief minister in the present case have actively caused obstruction of investigation by barging into the search premises, etc. Then K, the next page, because when the political executive uses state machinery to obstruct investigation, the rule of law ceases to operate, warranting immediate interference by constitutional courts. And I will show the judgments. Rule of law is a part, parcel, and heart of Article 14. Now, my lord, kindly see, my lord, what we do as, my lord, enforcement directorate. What is enforcement directorate? Take FEMA, my lord, for example. Lord, this is where, my lord, my existence stems from. And ultimately, my lord, what is the purpose of ED? I will show. The purpose of ED, we act on behalf of the victims of laundering, and we return the money. My lord, that's where my argument is going to be. My lord, please have a look at section 36, my lord, of FEMA.
Section
36 of Foreign Exchange Management Act. ED is constituted under this. It is not my case that ED is an independent department or it is a juristic person, etc. That's not, I am not putting it that way. They created a ghost, and in all the arguments they try to kill that ghost. That's not my case at all. The central government shall establish a directorate of enforcement with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purpose of this act. Without prejudice, your lordships are not concerned with the rest. This is where the ED comes into the picture. Now, only for one section, please have, my lord, PMLA. What is PMLA and what are we doing? Lord, whenever we find what is known under the PMLA parlance as proceeds of crime. Lord, one, there has to be a crime. Crime in the present case is illegal excavation of coal from the government refinery. Coal is a natural resource and that is being sold, and the money generated is transferred to various persons through Hawala transaction. That's the crime. The proceeds of crime would be obviously, my lord, in terms of money. Lord, that money, when we recover, what we do? Lord, please come to section 8. And I represent these people. Section 8, subsection 8. Lord, we take the matter to the trial court. Lord, there is a first attachment your lordships need not go in detail into that. But once, my lord, proceeds of crime are found, there is an attachment. Attachment results into, after procedure, my lord, followed, confiscation. Thereafter, matter goes before the competent court. But what happens to the money, my lord, which we recovered is 8. Where a property stands confiscated to the central government under subsection 5. I'm sorry, my lord, this is Anjari. Section 8, subsection. Lord, we attach the property, attach the money or property if it is converted, then it is confiscated to the central government. And thereafter, what happens, my lord, to that money? Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered quantifiable loss as a result of offense of money laundering.
Who are those in this case?
That the court will decide.
No,
the court will
it
decide.
is yet to be confiscated.
No.
It is yet to be confiscated.
I'm on a slightly different point.
Yes.
But for example, in a banking fraud, we have, the ED has under section 8.8 distributed to the identifiable victims 37,000 crores. 37,000 crores are given back under 8.8 as identified by the competent court to the victims of the crime. When I am prevented from exercising my duty or exercising my power, the affected party is the victim. I am also, my lord, invoking your lordship 32 on their behalf.
Who is the victim in this case?
Lord, that belongs to the people. Lord, that the court will have to decide.
It belongs to the Coal India Limited.
Yes. It would be
Coal India Limited itself is not a natural person.
It would be, my lord, I'm not on that. I'm on
in a given case where the victims are public at large. Money has been collected from public and that is siphoned and some XYZ.
Yes.
So the ultimate victim is the public at large. But in this case, the victim is the Coal India Limited.
Maybe the nation at large.
The subsidiary. So nation is also not a natural person.
I'm not colored on that.
Yes.
I'm saying that ultimately your lordships are protecting the victim of crime. Even if, my lord, we cannot identify the victim of crime, it will go in, my lord, the Consolidated Fund of India and will be used for the citizens of India. So this is not a case where the ED officials, my lord, per se, but before your lordship,
but in that
forget
sense,
8.8.
But in that sense, every government organization, statutory body is made, is established and is working to protect the rule of law.
Rule of law.
So then everybody can maintain a Article 32 petition.
No,
I'm there for the citizen of India. Every law is made for the benefit of
the lordships are
citizen
right.
of
No,
India.
that is one view. That is one view. I'm my lord, perfectly, my lord, in sync with what your lordships are respectfully. I'm respectfully in view, my lord, with what your lordships are saying. But here, lord, I am the officer of the ED. We are the officers of the ED. We are harassed. We are facing criminal investigation. And now please come to, my lord, page 29. Look, these are the 4 FIRs registered against us. By whom? By West Bengal Police. West Bengal Police is under the Honorable Chief Minister, under the Director General of Police, under the Police Commissioner, all of whom are, my lord, as I have already shown, are part of, my lord, the offense of destruction of evidence, trespass, illegal trespass, not permitting official discharge of duties, etc. Now, though those people have filed case against me, and I'll show, my lord, what is my prayer. Now, my lord, also see ground, my lord, at page 32, ground JJ. This is again, my lord, very, very interesting.
32 is OO. Page 32.
32 is OO, my lord, 1.
You said JJ.
No, I'm sorry, my mistake. JJ was earlier, I already read. Now, third incident, my lord, I am giving for complete breakdown of rule of law. While reading other instances, please see. Previously, Sri so-and-so, the MLA and the Minister of Transport in the government was arrested by CBI for his alleged involvement in the scam. Immediately after his arrest, respondent number 2, Honorable Chief Minister, called a press conference and lashed out, so-and-so, 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 and the officers were attacked. Then kindly come to page 34, ground 2. Again, this is Rajiv Kumar, therefore I will not repeat it. Please. And my lord, your lordships have known, my lord, even the judicial officers were crying. The one lady judicial officer was crying that what will happen to my family? 7 judicial officers' cars were attacked. And by order of this honorable court, the case was transferred to my lord, she's asking you a question. Your lordships put my lord, that recent incident, and she's asking whether it's a part of this petition. Yes, ma'am. They keep on wondering. Lord, then my lord, page 43. Ignore that. For that, the facts disclosed. Lord, I'll not repeat. But please now come to the prayer.
You maintain your rhythm, Mr. Mehta.
Yes, yes, I am maintaining.
Yes.
Nobody can derail me without my consent.
Yes.
If I am derailed, my lord, it is always when I want.
No, you.
Page 46 is the prayer.
You derail others, don't get derailed.
Yes, yes.
Yes.
Issue a writ of mandamus directing the.
Yeah.
Lordships have this scenario. There is a complaint by individual police officers as well as by the enforcement directorate in a representative capacity. Your lordships may even forget respondent petitioner number 2, one for the time being. The individuals are before your lordship. And the scenario is that I have given sufficient evidence to show that we are not permitted to discharge our obligation of investigation by interference by the highest political executive and supported by the DG, the police commissioner, DCP downwards, and that is the position. Now, these petitioners who are individuals, natural persons, discharging their official duties under the statute, are now facing FIRs. In that background, please look at the prayer.
This Robin is also facing a FIR.
Yes, I'll show about the FIR. They have not named. They have said those officers of ED. But Robin is the person who authorized the petitioners, other petitioners in the petition where Mr. Raju would be assisting. They are the authorized people. They were admittedly there for the purpose of conducting this search. They were the people who interacted with the Honorable Chief Minister. They were the people, named individuals who are petitioners, who said that you cannot take away this. This is custody. This is in our custody. This is the object of crime. And but for your lordship's protection, by now these officers would have been behind bars. CBI officers were taken to the police station. But our senior officials had to go to the police station and got them relieved. CBI officials were taken to the police station from the commissioner of police. I have made detailed averments from the house of the commissioner of police, where The Honorable CM, my lord, goes, stages a dharna outside the gate, and our CBI officials are picked up by local police and taken to some Sarani police station. That's the position, my lord. And therefore, this prayer, kindly have a look at the prayer now. Issue a writ of mandamus directing the Central Bureau of Investigation to register FIRs and investigate the entire incident in relation to the obstruction of ED's search conducted on 8th January 26 at both residential premises of one Mr. So-and-so as well as at the office of Messrs. I-Pac Limited, described in detail herein above, including the role of the present respondents being so-and-so, so-and-so, and so-and-so. But I cannot go and file this FIR before the West Bengal police that investigate your chief minister. Page 46.
Okay, prayer.
Prayer. I'm sorry, prayer. I just read for your lordship's consideration. Issue a writ of mandamus directing the CBI to register FIRs and investigate the entire incident in relation to obstruction of ED's search conducted on 8th January 26 at both the residential premises of one so-and-so as well as at the office premises of I-Pac, described in detail herein above, including the role of the present respondent number 2, so-and-so, so-and-so, so-and-so. Now, my lord, I am putting a question to myself. Can I go and file an FIR there when I am myself facing an FIR that investigate the role of Chief Minister, the Director General of Police, the Commissioner of Police, the DCP of Police, and 100 policemen who escorted them? I cannot. They have already filed affidavits giving them the clean sheet. Some independent neutral agency under your lordship supervision will have to go into it. This is not, my lord, a fight between A versus B. This is a fight where, my lord, a central investigating agency is investigating with proper documentation, and the political executive, highest political executive, supported by the highest echelons of the police department, comes and snatch away the incriminating material on the ground that I-Pac is also our political advisor, and you wanted some secret documents from I-Pac regarding our political part. That's not the, if at all, if it is a convincing argument, it must have convinced them, my lord, before making it. But that's the only argument. I show, my lord, the Honorable Chief Minister admits that I did go. The Director General of Police admits that I did go because she is a Z protect. So wherever the Honorable Chief Minister goes, the Director General of Police also is required to go because she is a Z protect. I'll come to that. Then one second. Direct immediate seizure, sealing, forensic preservation, and restoration of to lawful custody of the Enforcement Directorate, all digital devices, electronic records, storage media, and documents illegally and forcibly taken away from the search premises. Then issue a writ in the nature of mandamus commanding the respondent number 1 to 5 authorities, restraining the state authorities from interfering in proceedings under PML. Transfer. This I can pray only before this court. My learned friend, my lord, will assist your lordships on this. No other court, my lord, except the constitutional court, can say that give it to CBA. 156(3) earlier can never come into play. Transfer the FIR number so-and-so, 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 registered against any officer of the Enforcement Directorate with respect to searches conducted on 8/1/26 during course of investigation of the coal scam in West Bengal under ECR so-and-so to the Central Bureau of Investigation, which would be in consonance with the consistent with prayer A. Let their case also be investigated, my version be also investigated by CBI. So your lordships would not be deciding any disputed facts. There is one version. There is an admitted version of the other side. And now, what is that admitted version? Please take, my lord, the Honorable Chief Minister's affidavit. I'll read only one para. I don't wish, my lord, to sensationalize it. Just, my lord, it is necessary, my lord, for my purpose, my lord, as a legal proposition. That your lordships are not dealing with an fact which is in dispute, which will require not any adjudication. Not affidavit of respondent number 2. Reply affidavit of on behalf of respondent number 2. I read only one paragraph. Yes.
Second petition, first petition.
In the first page.
16, WP 16 May.
Page 5, para 12.
One.
Page 5. You are very seriously arguing about the extensive breach of law. It's very far-reaching overtones. We hope that you are not hinting at the breakdown of constitutional procedure. You are not, because that's a very larger concern.
That's a larger concern.
We hope that you are not driving at that.
But ED can never argue. I'll answer it in that fashion. ED cannot argue that. And I am for officials and the institution.
Page 5.
Because this position has been, my lord, since many years. My lord, what is contemplated, what is in your lordship's mind, Lord, could have happened earlier. My lord.
We don't know. We are only asking that whether.
No, Lord, ED cannot answer that. And it's not in my contemplation.
No, we
Page
are.
5.
We are
And your lordships, my lord, there is nothing of this.
There is no suggestion. This is just we are asking.
I'm aware.
In context of the controversy you are raising.
Whatever your lordship decides is not going to be used for a purpose other than what is projected in the petition. There is nothing of this thing. Let me be very candid and clear about it.
No,
it's not that I am seeking some.
That is also not the
question is also in relation to exercise of power under 32.
32.
Yes,
That's the limited point.
Is not.
I am answering rule of law because rule of law is connected to Article 14, which gives me a locus to file 30. That's the purpose for which I am using the word rule of, not for a breakdown of constitutional machinery. Page 5, para 12. Look, this is the Honorable CM's affidavit. Accordingly, the answering respondent visited Mr. Jain's residence at so-and-so at around 12:05 hours and was there for not more than 10 minutes. The I-Pac's office is in sector so-and-so to retrieve the above-mentioned data, which was both confidential and proprietary and vitally linked to the party strategy for upcoming legislative assembly election. Indeed, the petitioners have not been able to make out any case at all in the writ petitioners. So, my lord, for the purpose of, she believes that some political documents are being taken. She doesn't find out what is political and what is as per investigation of a crime. She takes everything with her and goes. And this is an admission. That yes, I did go. Now, Lord, kindly see the office, Lord, DG's affidavit. Director General of Police, the then Director General of Police, who is now, Lord, few days back, is a member of Rajya Sabha, Lord, he is no longer, Lord, the Director General of Police. Lord, page 10, para 14.9. This is his justification for being there. Lord, when I say that what is Director General of Police doing there? Because he will have to satisfy your lordships. Director General will have to say that wherever Chief Minister goes, announced or unannounced, his presence is necessary. Because she is a Z protector. She is a Z protector. I have no issue on that. This is I am pointing out only to show that facts are not in dispute.
Which affidavit you are referring?
The Director General of Police, the counter affidavit on behalf of respondent number 3, para 10, page 10, para 4.9.
Page 10.
Yes.
Para
14.9.
14.9.
arrival of the answering respondent at the spot and subsequent events. To show, my lord, that there are no disputed facts. The versions are disputed. I say he did that. He says I was for a different way. But the fact that unusual presence of the Honorable Chief Minister, unusual presence of the Director General, and, my lord, the factum of whatever we have retrieved was taken away unauthorizedly is not in this. 14.9. On 8/1/26, the answering respondent came to know that Srimati the Honorable Chief Minister had lodged a complaint at Shakespeare Sarni Police Station in her capacity as chairperson of All India Trinamool Congress.
Now, this FIR is lodged by the CM.
One of them is by the Honorable CM.
Where is that?
Two. I'll show that. Now, there is a separate. We didn't get it when we filed the petition. There is an additional volume. And all these arguments that you go there, register and face our FIR, why should you not face All India Trinamool Congress and was proceeding to premises at 7 so-and-so, Mr. Jain. From there, she had announced that she would be visiting the I-Pac office located in the Salt Lake area. Since the Honorable Chief Minister is a Z1 protectee and faces continuing security threats from various hostile and antisocial, anti-national elements, the answering respondent in discharge of his official responsibility relating to her security and overall public order remained alert and available at his office to coordinate with the concerned field formations in view of the rapidly evolving situation. Then, my lord, subsequently, as the crowd in the vicinity of I-Pac office began to swell, the answering respondent directed deployment of additional force. Then 14.11. Accordingly, at around 13 hours, the answering respondent reached the spot since Srimati so-and-so, Honorable Chief Minister, was inside I-Pac office at 11th floor of the building. Subsequently, the respondent held a meeting with so-and-so of the West Bengal and took necessary instruction on the matter related to the security and public order. Very innocently, my lord, he is discharging his duty. Then, my lord, 14.13. Then, at about 16.25 hours, Srimati so-and-so, the Honorable Chief Minister, left I-Pac office to attend the program at the so-and-so area within the jurisdiction of Calcutta Police in connection with the ensuing Ganga Sagar Mela. The answering respondent remained at the premises, that is, my lord, I-Pac premises, after departure of so-and-so, as the Honorable Chief Minister was to return to the spot upon conclusion of the program. That you stay here till I come back. So there he permitted the Honorable Chief Minister to go alone. There was no security concern of the Z protectee because he was under a mandate that you now stay here in I-Pac office till I return. Then next. After waiting until approximately 18.30 hours and upon receiving official confirmation that so-and-so, Honorable Chief Minister, would not be returning to the premises, the answering respondent left the location. Till then, my lord, he very obediently remained at the location, leaving the security of the Honorable Chief Minister, which he purports to, my lord, guard 24 hours. Then, my lord, similar is the Commissioner of Police, my lord. Counter affidavit on behalf of respondent number 4. At page 6, para 13.3. Lord, my version that for police force of 100, Lord, is admitted. Truth always has a strange way of coming out. Para 13.3. Subsequently, Sri additional officer in charge of Shakespeare. Page 6, my lord. Bottom.
Counter of R4.
R4 is Commissioner of Police, Calcutta.
Para
page 6, para 13.3. Yes. My Lord Justice. Subsequently, Sri so-and-so, additional officer in charge of Sector Sarni Police Station and Sub-Inspector Vishwajit Vishwas proceeded to the spot with a force at 9:45 a.m. to make the necessary inquiries. The armed persons claimed that they were CRPF officials, but they did not show any identity cards. Then, my Lord, para 8, page 8, first para, my Lord. Thereafter, at around 11:50 a.m., officers of ED came downstairs, disclosed their identity, and informed the Deputy Commissioner South that a search was being conducted under PMLA. The Deputy Commissioner sought verification of authorization for such search, and an ED officer expressly requested him to accompany them to the premises for the limited purpose of verification. Well, thereafter, he also says that the Honorable Chief Minister came, etc., etc. So, my Lord, the point is, now, my Lord, see the FIRs. FIR does not name me, but when FIR says responsible officers means there is an authorization. Therefore, my Lord, I read the first part that petitioner number so-and-so was authorized by petitioner number so-and-so to conduct the search and seizure. It is not in dispute that Mr. X, Mr. Y, and Mr. Z, who are before your lordship, were part of, my Lord, the search team, and they interacted with everyone. Now, please see, my Lord, there is a additional document, IA 109682 in the second petition, my Lord. Yes, read petition 17 of 26. Yes.
Yes. 109682.
Yes. But first, please come to, my Lord, the two FIRs which are filed by the Honorable Chief Minister. Page 72, page 71. It's a typed copy, my Lord. At 73, name of the complainant.
1 minute, 1 minute. So, yeah, page
71, it starts at 71.
This is filed as party president.
Party president.
But she doesn't cease to be the chief.
Yes.
Yes, yes. It's as a party president.
In other cases, capacity she cannot file.
Yes.
In her own name.
Yes. As a party president. So that that is at page 73. Name of the accused, my Lord, are not shown. They are not shown as officers of PD. Where is that?
No.
And content, my Lord, page
1 minute,
75.
1 minute.
Brief facts of the case.
The name of accused is?
Blank, my Lord, page 74. It is blank. So that anybody can be accused, my Lord. That's, my Lord, a known phenomena in FIR registration. But see, my Lord, we'll get from the content of the FIR itself. Page 75. Brief fact of the case is that the unknown accused persons claiming themselves to be officials of enforcement directorate, illegally and unlawfully. Your Lordship would remember, the commissioner says that they have shown their identity cards. Unlawful committed criminal trespass and house trespass by entering the residential flat of Mr. Pratik, one of the directors of Indian so-and-so, a trusted strategic associate of AITC, situated at so-and-so without lawful authority and under the false pretext of purported search and seizure operation. During the course of such illegal entry, the accused person dishonestly and without consent removed, accessed, and misappropriated sensitive, confidential, and proprietary data documents and materials, including electronic records, digital devices, and storage media containing political strategy, campaign-related information of AITC, and data pertaining to the SIR process Furthermore, the accused persons acting with deliberate intent and ulterior motive, they fraudulently and dishonestly copied, transferred, and cloned the said sensitive electronic data and documents, including by engaging or taking off assistance of forensic and technical experts, thereby committing house trespass. Lord, the person from whose custody all this is going is not the complainant. He knows, my lord, what was recovered by the ED and what was incriminating with regard to that offense. Look, there are 5 FIRs, my lord. I'm not reading each. 4 FIRs, 2 by the Honorable CM, raised by the police themselves. There is no private FIR. Now, my lord, I'll deal with, my lord, the legal submissions made. But maintainability of a 32 cannot be divorced from the facts emerging from each particular case. It cannot be argued as an abstract proposition of law. Or can I say after lunch? Almost.
Yes. Bulan.
But I'm sorry. But there is nothing up the sleeve. Again, at the cost of repetition, rule of law argument is to bring it within 14 and maintain it. We'll show that we have the judgment. We are showing nothing, my lord, other than what is on the record.
Chips on fixed item 39 today.
Rest of the board is discharged.
39 if the lordships may fix a date, Tuesday or Wednesday, if I may pray for.
So what is that?
That's that insurance part third matter, your lordship. Small, little MACP matter.
Not to
39. 39.
39 week after next president.
34. Sorry. 34. 34.
34.
34.
Yes.
Very good.
बाकी बोर्ड स्टार्ट कर दीजिए. Yes. Yes, Mr.
Yes. So kindly take my written submissions and I'll hurriedly assist your lordships and take my.
I can't see your lordships, Mamata. This way I can't see your lordships.
So, for the first time, inside the court, I find his presence very soothing.
Page 97. First time only. Why first time?
Context.
The context, my learned senior knows, no? We are.
No, he was here.
He was not.
Yesterday he was on the screen, but before that he was here.
But I am reminded of one very interesting incident.
Yeah.
Winston Churchill was the leader of opposition. This is something very interesting. And some member of the House of Lords, House of Commons, was going on and on and on and on. Winston Churchill wanted to convey that now it's enough. You are spoken long enough. Winston Churchill was finding a way out. He saw another member using the earphone. He was deaf. So he was using the hearing aid, not earphone, hearing aid. So he said, gentleman, just wait for a minute. I want to know the name of this gentleman using the hearing aid who is denying himself the natural advantage. I was reminded of that. Can you not kindly take my written submission?
So Symbol has never used any hearing aid.
No, he has not. He is younger than all of us.
Yes.
Younger and more smarter and handsome than all of us. I tell him, I tell him outside the court also.
Curiosity is overwhelming.
I tell you lovingly, outside the court also, and I mean every word of it. So kindly take my written submissions and I hurriedly take your lordships through this, but I'm not going to read basic propositions your lordships are not fully aware of. But please come to page 9. Some of the judgments. Or page 11.
Page 11.
Yes. It starts at page 9 bottom. Page 10 bottom, sorry. But, apropos, my Lord Justice Anjaria's question. This is the judgment I am relying upon. That rule of law is a part of Article 40. And individual officers are entitled to invoke your Lordship's 32 jurisdiction if we can show that there is breakdown of rule of law only for that purpose and nothing more. Please have a look, my Lord. Rule of law means wherever and whenever the state fails to perform its duties, the court would step in to ensure that the rule of law prevails over the abuse of the process of law. Breach of the rule of law amounts to negation of equality under Article 14. Well, this is what I rely on. And this is the limited purpose for which, my Lord, I would earnestly request your Lordships, my Lord, to hold that the facts and circumstances emerging from the present incident and past incidents which I have managed, which I have, my Lord, already pointed out, results into, my Lord, violation of Article 14 of the officers who go there to discharge their duties. Then, my Lord, next is Manohar Lal Sharma versus Union of India. Kindly see only the highlighted part. The aim of investigation is ultimately to search for truth and bring the offender to book. A proper investigation into crime is one of the essentials of criminal justice system and an essential facet of rule of law. My Lord, therefore, essential facet of Article 14. Then, my lord, Meghwendra Prasad Singh, again, my lord, rule of law is a part of Article 14. I am not, my lord, reading it further, my lord. Then, page 12. I am sorry. Page 12, my lord, para 17. As observed and held by this court in the aforesaid decisions, the victim has a fundamental right of fair investigation and fair trial. Now, this is what I am seeking. Not forget petitioner number 1 for the time being, in my case. Petitioner number 2 is, my lord, victim of this. And all petitioners in petition which my learned senior friend Mr. Raju would argue are also, my lord, individuals demanding.
No, but you are not victim on offense.
Offense.
You may represent the victim as according to
I'm
you.
not victim in the Lord. I have removed that 8 section 8 subsection 8.
Yes.
I'm not on that. My lord, this is how we are treated. And I want your lordships, my lord, I'm praying for your lordships that let an FIR be registered. We were doing our duty. We are victim in the sense that the documents and material incriminating evidence collected by us is taken up. Not, my lord, victim in the sense of section 8 subsection 8. Then Zahid. Yes. Now, my lord, kindly see.
No, here probably you are saying that victim of that offense acquire the FIR which is registered against you.
Yes. Yes. And therefore, I am saying, my lord, that police can never do justice to me, my lord. Because FIR is registered by, my lord, a chairperson or the president of a political party who happens to be the chief minister. And according to my case, my cross FIR, which I am requesting your lordships to direct CBI to register, because even the Director General of Police is also an accused, the Commissioner is an accused, etc. Then your lordships may kindly see page 15, my lord. Similar, my lord, are the observations, but I may not read all. My lord, page 14, my lord, para 22. Lord, Union of India's Article 32 petition was entertained. Lord, then Bandhuwa Mukti Morcha, my lord, I have referred to and, my lord, highlighted, para page 16.
So that is what precisely their argument was, that you are not Union of India. You are a department of Union of India, and there is no sanction or permission from the Union of India.
Lord, forget about everything. I am saying petitioner number 2 is an individual personally aggrieved, and he is before your lordship saying that I cannot go before Calcutta Police, by West Bengal Police. And he wants that let this incident, which factual adjudication your lordships are not required to go into, be investigated by CBI. Then, my lord, when, my lord, your lordships are faced with extraordinary situation like this, my lord, where I don't wish to keep on repeating the same thing, but your lordship knows the extraordinary situation, which is not just a standalone single incident, but a pattern of incidents. Now, your lordships have, my lord, what is known as epistolary jurisdiction. My lord, that's an inherent jurisdiction of your lordship. This is under this jurisdiction that your lordships exercise powers even on a postcard. No locus standi, no formal proceedings, no filing of the petition, etc. is needed. Ultimately, your lordships will be satisfied only if your lordship feels that there is a violation of fundamental rights, which requires the intervention of the highest constitutional court of the country, under an article which itself is a fundamental right. Then it would never prevent, my lord, your lordships from exercising this jurisdiction. Then your lordships may kindly see. My lord, I take two submissions, my lord, and I raised, my lord, my learned friend would conclude, my lord. But I want to, my lord, address two issues, my lord, raised by the other side, especially Dr. Singhvi. Dr. Singhvi argued, based on essentially the judgment of STC Limited, that ED is not a citizen and therefore cannot maintain a petition. Do not forget the ED. Kindly concentrate on petitioner number 2. But that apart, as a principle of law, kindly see, my lord, for this, I hate to show this, my lord, Article 14, but Article 14, 21 and 19, this, my lord, as Supreme Court says, golden triangle. 19 says no citizen will be deprived of these rights. Article 19, kindly see, my lord, your lordships have seen, if your lordships have seen, your lordships did not. All the judgment.
No, we'll again see.
Pardon?
We'll again see. Every time it has to be seen.
No, they did not.
No. I'm seriously saying. Because I have learned that whenever you use any provision of law, you must read it. You must read it before you invoke or you go through it. Because every time you read, there will be a new reading, new kind of thought process which goes on.
Facts, new nuances.
Yes.
But my lord, all judgments cited by Dr. Singhvi, my lord, were under Article 19, particularly 19(1)(g). But whatever is the 19.
14 and 21 is person. That's a distinction.
Yes. And my lord, 14 has another distinction. State shall not deny to any person equality before the law. But I am extending a step further, saying that equality would mean rule of law. So if I can show that there is failure of rule of law, or there is a likely failure of rule of law, that would violate my Article 14 rights. My 14 right means petitioner number 2. Lord, ED is in a representative capacity. Lord, kindly examine this from this point of view. ED may not itself has any fundamental right, but ED represents that all agencies going in particular state is meted with brutal police force at the behest of and in presence of the highest political executive. Then ED says that I am coming before the court in a representative capacity for all officers who are doubtlessly citizens of India and natural persons. But by way of abundant caution, petitioner number 2 is undoubtedly a citizen of India and a natural person.
You see, the argument was ED doesn't have a fundamental right. And the officers of ED are representing ED. Therefore, they also don't have fundamental right. Because that is what the argument was. Then you have to meet it.
So, I don't
like you see STC and other line of judgments, they have referred to wherein shareholders of a company was also joined along with the company, and yet this court has said that the shareholder of the company represents the company. He has no independent right, qua 19(1)(g) or any other thing, then greater than the company.
I understood.
And therefore, that time I wanted to raise a query that the theory of a shareholder representing the company
in a business
concern,
19(1)(g) would be totally different.
But here, they are not shareholders in that term of the sense.
So in any sense,
ED officers, they are not shareholders. They represent not only as ED officers, but when a crime is registered against them in some police stations, it is their person which is involved. Apart from ED, the offense is qua the individual, and ED is not involved. There the distinction lies. This question is for them, they will answer it.
I would give one more example.
Yes.
Take a case where ED has to sell certain property. for the purpose of recovering the amount and distributing in wherever it is to be distributed. And it auctions the property. ED would be in the Article 19 capacity. Then officer may perhaps, I do not know what would be the officer's position. But I am not doing any business. ED is not saying that my right to carry on any business, my right to speak, my right to assemble, my right to move throughout the territory of India, etc. is being hounded. Article 19 centric judgments can never decide the present controls. Article 19 is for individuals. ED is a mechanism under the statute which represents its officers and pointing out that my officers, we are not doing any business, we are not claiming any Article 19(1) rights, but our Article 14 rights are violated. Suppose ED's officer is detained illegal. Take for example, ED's officer is detained without following the procedure under Article 20, 22 or 21. ED and that officer can come, that the similar position is emerging from various states, our officers are being picked up. There, 19(1) analogy cannot apply. There, ED only comes in a representative capacity, not saying that it is my right, any of the fundamental right which is violated. It merely says that what is violated is the right of petitioner number 2, who himself is now facing an FIR, who wants an FIR to be filed so far as his version is concerned, and therefore please ensure rule of law and ensure compliance with Article 21, that nobody would be dealt with except in accordance. Well, that is the distinction. When we start using 19(1)G judgment or Article 19 judgment, for the purpose of deciding the present case, that is where the confusion is created. And I don't believe Dr. Singhvi is not aware of that distinction. But I understand that's his contention available to him. He has raised it. But Article 19 has no place in fact situation of this nature. It's only 14 and 21. My right to be proceeded in accordance with law. And when I say my right, means my officers. When I say my right, petitioner number 2. And when I say my rights, all the petitioners in the second petition.
So therefore, you are asserting your fundamental right in official capacity.
Yes, Father.
So fundamental right can be in personal capacity. In the context of official capacity, we don't know whether such right can be asserted. The remedy will be different.
No, there is no remedy, Manoj.
So therefore, the person was asked to Mr. Subal that the fundamental right are person-centric.
It is person, Manoj.
Or may arise in a different context of this.
I am putting a question to myself. If I am
this is the third dimension that you are now asserting the right in official capacity.
No, Lord, I'll answer that question. Lord, if a lawyer finds something being done to him under Article 14 or 21, merely because he happens to be in his discharge of official duty, would he cease to be a person? There is no distinction under the Constitution, Lord, I'm sorry. There is no distinction. What would happen whether it as a person or as an officer? I am facing an investigation by an agency. The Lordships have seen which agency. As a person or as an individual. An individual who happens to be donning a particular uniform. Lord, police officers do come before your Lordships. That this is the way we have been treated. Lord, if this view is taken, Lord, suppose a police officer in his discharge of his official duty is, say, dismissed or suspended. Then he is suspended as a police officer, not as a person, and therefore he can never file a petition under Article 226. Because then we will be closing doors of justice. The excess of justice would be denied. But kindly, Lord, imagine a situation. Forget, Lord, facts of this case. A police officer in uniform, for having done something or having not done something, is placed under suspension, and he approaches either this court or the High Court. If his capacity as an individual is different and his capacity as a police officer is different, he can never approach for his fundamental rights, which in my submission doesn't born out from the constitutional principles.
Yes.
You mean to say these two characters are inseparable?
Inseparable.
An individual who is an officer has to come individually asserting his rights as an officer or in service law or whatever, in criminal law.
He may be facing an illegal act in his official capacity, but the impact and the consequence would be on his person. But my liberty would be taken away. It's not the officer's liberty which is taken away. It is the individual's liberty will be taken away. If I am falsely implicated in an offense, maybe the genesis is because I am an officer of a particular department. But the impact or the final of effect would be on my individual. Lord, if we would be trading a very, very hazardous line, Lord, and we would stop access to justice, Lord, if this is separated. So, Lord, that is my argument. Lord, another argument raised was Article 131, that this would be a case of a dispute between the center and the states. Lord, first of all, on the face of it, there is nothing, central government has nothing to do with this issue. State government as a constitutional body has nothing to do with this issue. The president of a political party, who happens to be the chief minister of the state, is the accused. And officers of enforcement directorate, who happens to be working and drawing salary from the central government, are on one side. Union of India has no issue with this. State of West Bengal may support them, but they have no issue with it. Lord, it is preposterous even to argue in facts of this case that this would be a case under 130. But there is one judgment, my Lord, which I would in the written submissions, Lord, I have, there is not a judgment, Lord, it is a contention that even if it is traceable to 131, then only it has to be between union and the state, not a department and the state. Otherwise, Lord, what happens? Lord, suppose a dispute between, say, tax department of the union and we have quoted the relevant part, but if you want, we can give the copy.
Because I don't know what to answer because they have given only quoted paragraphs of the judgment.
I shall give it to you.
So give us the compilation so that I can answer it.
Yes, sir,
He said I haven't made it, that's what I'm saying. I'll give it, thank you.
You have other copies.
Yeah, copies.
Okay, then that's what I wanted.
No, he only said we have not given it to the court.
Yeah, but
that's what
it is, I think.
But that's okay. It's too, between us, it's too small a thing. Even if we don't rely upon, we can give it. There is no. So, the department of the government having a law and order issue with the state functionary can never become Article 130. Article 131 issue is completely different, where there are federal issues raised, where there is genuinely a dispute between state as a constitutional unit and union as a constitutional unit. Say river disputes, other boundary disputes, etc., etc. This is an argument of desperation that please don't enter into the merits of the case because the facts are very, very embarrassing. And the last, I don't think that submission was, I hope was not raised with seriousness. That matter should go before a constitutional bench. Day in and day out, whenever 32 is filed, we raise the contention as respondent that 32 is not maintenance. Would that, I'm posing a question to myself, become a question of substantial question of law where 5 honorable judges will have to spend time? There are a large number of cases, my lord, where 32 is filed day in and day out. And we do raise a contention. But it is always, my lord, your lordships, my lord, in a sitting in combination of 2 honorable judges or 3 honorable judges. So, my lord, to say that this has to go before a constitution bench, my lord, may not be a. So, my lord, my respectful submission is to summarize my argument, my lord, and then your friend will argue. Lord, ED in representative capacity, petitioner number 2 in his own capacity, personally as well as officially, and other petitioners in, again, personal as well as official capacity as citizens of India are before your lordships, seeking their fundamental rights under Article 14 and 21 with a prayer that whatever has happened to us be investigated by a neutral investigating agency, and whatever we are being accused of by a very engineered or orchestrated FIR filed by the accused themselves be also simultaneously clubbed and decided together. So that is the respectful submission. My learned friend would.
In my petition, Lords, which is number 17, there are 3 petitioners. All 3 happen to be incidentally they happen to be. Petitioner number 2. Halwa. Lord, he is the person in whose name the authorization to search under 17 was issued. That, my lords, will find at page 71 and 72 of the petition. If my lord has a look at page 72, which is annexure P5, is an authorization without which a search can't be conducted. Legal search can't be conducted. It's dated 7th of January 26. Search to be conducted at 11th floor Godrej Waterside Tower. That is the office premises of I-Pac. And kindly have a look, my lords. The person was, it is issued. I hereby authorize Dr. Vikram Ahalawat AD, Assistant Director. So authorization is in his name. He was authorized and he conducted the search. He was present at the time of incident. And then kindly have a look at the second person, my lord. That is petition number 3, Prashant Chandela. That, my lords, will find at page 62 and 64. The authorization in his name. Page 64, my lords, you kindly have a look. This is for the residential premises of Pratik Jain. I hereby authorize Prashant Chandela, AD, Assistant Director, to conduct the search at 3rd floor, Loudon Mansion 7. So this is the residential. 71, 17, same. Same. And they are present during the search the incident happened in their presence. Offences were committed against them. What are the nature of offences? I'll take my lords to them, which includes wrongful confinement, theft, robbery, dacoity. I did not go into that because they had not seized, but they had taken into possession documents and digital devices. And that's were taken away by respondent number 2 from them. So theft, you need not be owner, but possession is a requirement for the commission of the offence of theft. So if you are in possession, whether as the owner or not, and if the thing is taken away from you, property is taken away from you, offence is committed, you need not be the owner. So they were in the case is that during the search, we took into possession certain articles which included devices and documents. That was in the possession of petition number 3 and the other petition, which was snatched and which was taken away. Therefore, prima facie offence of theft. That's the case. They were wrongfully confined is also their case. Now, my lords want to say the gist of all those offences, which is there in my petition. It's 15. Chart. Yes. Kindly have a look, my lord, at page number 37 and 36 and 37 and 38. These offences which we are alleging to have been committed. 49 is abatement, 61 is conspiracy, 121 voluntary causing hurt to deter public servant. This is personal. You cause hurt to, maybe in his capacity as a public servant. If he is not a public servant, then 323. But anyway, hurt is a personal offence. Wrongful restraint, wrongful confinement is against personal. Force, criminal force. Assault or criminal force to deter public servant for discharge of his duties against personal. Obstructing public servant in discharging public service against personal, though he is working in a capacity. Then, my lords may see there is large theft, etc. Theft in a dwelling house. Theft of a preparation made for causing death because large number of them were armed or not, but this is our allegation, house trespass, etc. So what I'm trying to say is that all these offences, many of them as a personal, have been committed against them. Therefore, they are not only aggrieved, but they are victims. Kindly have a look at now section 2Y of the BNSS. They are victims. They would fall within the definition of victim. BNSS.
But most of the offences may not be made out.
But that the investigation would make out. But it is at the stage of investigation. After investigation, they may not be made out. But prima facie, it is our case that these offences are made out. Because more than 5%, etc., we have made out a case. It is for the investigating officer to say that the offence is made out or not. The investigating officer may not even register some of the offences at the time of registering of the FIR. So this is our case at this stage.
No, but
now, my lords, we kindly have a
the premises doesn't belong to you. It was of Mr. Pratik Jain's.
Yes.
How can there be a theft?
Yes. Now, kindly have a look at 370.
For constituting a theft in relation to those documents, now there has to be a formal seizure by you, and thereafter they took away.
No, possession.
But you have not seized those.
Possession and thereafter seizure. That's our case, my lord. But possession is a required. But individual cases, I need not go in, but this is our case. Possession is a requirement of theft, not.
You may say whatever offense is made out, it will be made out after the investigation. But you cannot say by quoting these provisions and these offenses are made out.
This is our case. My lords are right. This is our case.
We cannot record a finding that this is made out.
No, I'm not saying it is our case, my lord. Therefore, it is our case. Now, kindly have a look at the definition of victim under section 2Y of the BNSS. My lord.
Two?
2Y. Victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person and includes guardian or legal heir of such victim. So I would fall within the definition of victim I am not pitching my case because I'm not representing ED, that ED is my guardian and therefore I'm not pitching my case so high. In some of the foreign countries, even corporate entities are treated to be guardians. In a given case of corporate entity can also be treated, but I am not arguing for the ED. So my case is I'm a victim. Now, what are the rights of a victim against whom an offense has been committed? The right is that if it's a cognizant offense, that an FIR is registered and is investigated in a fair and proper manner, fair, equitable, unbiased, impartial manner. That is the right of a victim. That flows from Article 21. The right to have an offense committed against a victim or against a person to be investigated properly without an apprehension that it be biased is a right which affects my liberty, therefore falls within the facets of Article 21. This is my first contention. Secondly, my lords will kindly have a look before I proceed further, my lord, because 2Y talks of injury. Now kindly have a look at subsection 14 of BNS.
BNS.
Injury need not be physical, though we have alleged that it can be mental also. Again, 2 subsection 14. Injury means any harm, whatever illegally caused to any person in body, mind, reputation, or property. This will have to be read with 2Y when you look at the definition of injury. I'm not relying on the ingredients, I'm only showing my right to get justice in the form of a fair, equitable, unbiased, impartial investigation. That is my fundamental right as far as Article 21 is concerned. As far as that is concerned, my lords will kindly have a look that if the regular procedure as envisaged by section 154 and 156.3, which was argued, is followed, I will not get justice and that will not be a fair and impartial investigation for 2 or 3 reasons, my lords. The first reason is the officer who is going to investigate is going to be the officer in charge of a police station, who is subordinate to the Director General of Police, subordinate to Commissioner of Police, subordinate to respondent number 2, who is not only the Chief Minister but also happens to be the Home Minister. It also happens to be the Home Minister. And there is going to be no fair, impartial, equitable, reasonable investigation if the officer in charge of a police station investigates. Because 154 envisages that the investigation has to be done by an officer in charge of a police station if it is read with 156.3, my lords. This is old CRPC, my lord. I will come to the new BNS would be 173.
BNS 173.
173. Just give me a minute.
Equal to 156.
154. Just give me a minute. 170. My lords. So you have been in the old book.
No, sir. Not good.
Equivalent to 154 and 175 is equivalent to 156. 3. Now kindly have a look at 175. The other side refer to the old code, but it's almost similar, therefore, my lords. Any officer in charge of a police station. So who can investigate? Officer in charge of a police station may, without the order of magistrate, investigate any cognizable case, with the court having jurisdiction over the local area within limits of such station would have power to inquire into a try under the provisions of this chapter. So only an officer in charge of a police station can inquire or investigate. Now kindly have a look at subsection 3, my lord. Any magistrate empowered under section 210 may, after considering the application supported by an affidavit made under so-and-so, and after making such inquiry as it thinks necessary, and submit, may made in this regard by a police officer, order such investigation. Such an investigation refers to an investigation under subsection 1. Now this has been considered by your lordships in the case of CBI versus State of Rajasthan, lords. 2001 3 SCC page 333. Is the paragraph. Trying to see, but I'll come straight to it. 16. I don't want to take.
Para 16.
1-6. As the present discussion is my lords have got it?
Yes.
As the present discussion is restricted to the question whether a magistrate can direct CBI to conduct investigation in exercise of its powers under section 153 of the code, it is unnecessary for us to travel beyond the scope of the issue. We therefore reiterate that the magistrate's power cannot be stretched under said subsection beyond directing the officer in charge of a police station to conduct the inquiry. So only a power that the magistrate is having is directing the officer in charge of a police station. If I go to an officer in charge of a police station who is under all these heavy and mighty accused, there is not going to be a fair investigation. Therefore, this is almost a remedy which is a mirage. Therefore, my remedy, therefore, their entire argument that no, they have a remedy to file an FIR, they have a remedy to go under 156(3) is not there when I want a CBI investigation.
You are answering that Sakari Basu.
Sakari Basu also, there's one of para 29 has something in my favor, but I'm only saying this. Therefore, I have this actually no remedy because it is from going from one place.
The reason for which you have come under Article 32
yes.
is also a reason why you can't go to the SHO or Sakari Basu.
Yes. That is what I am. Yes. And why I have come to 32, my learned friend has argued for that High Court also what happened, etc. Therefore, I come under 32. That is my submission, which I am adopting. Caesar's wife, my lord.
You may be on a better
fire pan to the fire or fire to the fire. Frying pan is the thing. Therefore, 156(3) is no remedy. I'll also demonstrate from the FIR when I come. One of my alternate prayer is that the other FIR should also be transferred to CBI. I'll address my lords on that. But when I come on that, I'll also show the why the FIRs contains false averments, false statements, etc. I'll come to that a little. Apparently, without making any much submissions, relying on their affidavit. Therefore, this I am answering the first question as far as 156(3) is concerned. I suppose this takes care of the issue that they have raised. Even Sakiri Vasu, my lords, kindly have a look at para 29 of Sakiri Vasu. Para 29.
Yes. Gina, Sagari Vasu. Citation.
Citation is 2003-6 SSC 195, which has been referred to. Right. Yeah. Sorry, 2008 to SSC 409. 2008 to SSC 409. The other side is referred to it, para 29. Very good.
Read that we have.
Para 29.
Para 29. It starts in Union of India versus Prakash P. Hinduja. Union of India versus Prakash P. Hinduja. It has been observed by this court that the magistrate cannot interfere in the investigation by the police. However, in our opinion, the ratio of decision would only apply when a proper investigation is done by the police. If the magistrate on an application of 153 is satisfied that proper investigation has not been done or is not being done by the officer in charge of the police station concerned, he can certainly direct the officer in charge of the police station to make a proper investigation. So he can only direct the officer in charge of the police station. Officer in charge of the police station is under response number 234, and there is no fair investigation which can ever happen. Therefore, my lords, even Sakiri Vasu, my lord, says, and para 31 may be looked at, my lord. Investigation.
Sakari Vasu is within the framework of CRPC. Magistrate will direct investigation within the framework of CRPC.
Yes, and framework
Not
of
beyond that.
The framework of the CRPC doesn't travel beyond the officer in charge of police.
You understand?
Now, my lords, may kindly look at the two FIRs and certain things. Even look at the manner in which the two FIRs have been registered, despite knowing that the officers conducting the search were ED officers. They registered an FIR stating that unknown persons or persons claiming to be ED officers have conducted the search. Did you have a look, my lords? At first, my lord, FIR number 3 of 26. The FIR number 4 of 26, my lords. This is a document compilation on record, my lords. Page. It is also part of the affidavit of R4, my lords. Just give me. But my lords will find it at page 28 of the affidavit. Of the affidavit of just a minute. Respond number 5. Respond number 5's affidavit in 16. Kindly have a look at page 28 of that affidavit. My lords will note the time of the FIR, 12 o'clock. Right hand side, date and time of the FIR.
Yes. Copy of the FIR. You are referring to the FIRs.
Yes, FIR is annexure R2 in the affidavit of R5 at page 28.
Page?
Page 28 is the FIR.
Continue.
On the right hand side, my lord, date and time of FIR is mentioned at 12 hours. My lord, so got it?
Yes.
Kindly note this time, 12 hours. Now kindly look at the complaint.
Occurrence 11:20 hours.
No, my lord, that is FIR 3. Kindly come to FIR 4, which is at page 28.
Page 28 is some
4 of 26.
page 27.
20. R2, my lord, sir, having annexure R2.
R2 is at page.
My lords are looking at affidavit of R5. Counter affidavit of
Yes, counter of R5 in your petition.
in their petition. 16.
16.
16.
16. So it is not there in your petition.
In our petition, we
have filed all petitions, all in our petition, my lord. All FIRs are filed. But
yes, 28.
28, my lords may kindly have a look. The time is FIR number 4, and it is 12 hours. My lords have got 12 hours.
Yes.
16 right. Now kindly come to page 32, my lord. The gist
No,
of the
occurrence is 5 hours.
No, my lords are having FIR 4.
FIR 4.
Yes.
Occurrence of time.
Not occurrence, the date of registration of FIR.
Date of registration.
Just the same line as 000004.
8-1, 12 hours, 12 noon.
12.
Yes.
Now, my lords, at 12 noon, what is the FIR? Kindly have a look at page 32. Brief facts at page 32, my lords. First paragraph. Brief facts of the case is that unknown accused persons claiming themselves to be officials of Enforcement Directorate illegally and non-lawfully committed criminal trespass and house trespass by entering residential flat of Pratik Jain, one of the directors of Indian Political Action Committee, a trusted strategic so-and-so situated third floor. So at 12 o'clock, they say there are unknown persons claiming to be, my lord, officials of ED. Now kindly come to page 8 of the affidavit. Right. Page 8, para 25. Thereafter, at around 11:50 a.m., I also got it.
Yes.
The officers of ED came downstairs, disclosed their identity. Therefore, at 11:50 came to know that they were ED officials, disclosed their identity. Then how can there be an FIR at 12 o'clock that they are claiming to be ED officials? Therefore, an attempt is made to create a false FIR, prima facie.
the Commissioner of Police, para 13 corresponding with
Same is written by the Commissioner of Police at page 8 of his affidavit. R4, my lord, affidavit at para 13.7. Para 13.7, my lords may have a look. So they came to know at 11:50 that they are genuine ED officials, identity was disclosed, yet they filed a false FIR at 12 o'clock. Para 13.7, this is the affidavit of the commissioner, my lord.
Now, our court.
Page 8. Thereafter, at around 11:50 a.m., officers of ED came downstairs, disclosed their identity.
13.7.
Yes, page 8 of the commissioner's affidavit. Thereafter, at around 11:50 a.m., officers of ED came down, disclosed their identity, and informed the Deputy Commissioner South that a search was being conducted under PMLA. Sought verification of the authorized or expressly requesting to accompany into premise for the limited purpose of verification. At 11:50, they were already informed about the verification. Therefore, a false FIR on the face of it. This is as per their pleading, but not my defense. It's their own case. Now come to FIR number 7, which is at page 34 or 37.
34
34 and 37. Our document compilation. Document compilation is already given earlier. It's a part of IA. Kindly have a look at page 30. FIR number 7 of 25.
Filed in which matter?
17 of 26. 1096.
Document combined. Yes. Page 34.
I'll just page number
34.
No, it is FIR is at page 34. Kindly have a look at page 34. You show it to me, doctor. Where is it? My lords are having page 34 minutes.
Yes.
Kindly put the time here of the FIR. Now kindly have a look at the time, lords. Starts at 34.
22.05 hours.
22, yes, I'm on that. 22.05 hours, which is at page 36. So FIR is registered at 22.05 hours.
Occurrence 8:15 hours onwards.
Yes.
That was night, 10 p.m.
Night. Now kindly look at the gist of the information, my lord, which is at page 37. High Inspector Ram Narayan Pal, my lord, page 37. High Inspector Ram Narayan Pal, in charge, this is police station, like to inform that today, 8/1/26 at around 8:05, source information received that some persons have entered the office of so-and-so, 11 Godrej for so-and-so. As soon on receipt of I, along with available force of left the police station about 8:10 to verify the same. Matter was diarized by the electronic complex BS so-and-so. On reaching the above mentioned place at about 8:15, I found the personnel with long arms in camouflage dress without nameplates were standing at the entrance of the office at 11 o'clock. When I tried to enter to verify the information, then they restrained me and my officers by force. I went to verify the source I received, and on being restrained, the hot altercation started by them, and there 3 or 4 persons with CVs came out from there inside the dictating a gesture directing to leave the place by starting. While I asked for their identity, since they were in CVs, then they refused to disclose their identity, so therefore identity is not disclosed. Now kindly come to the email which has been sent to them at 10 a.m. on the same day. That, my lords, will find at page affidavit of R3 in writ petition 16 at para 14.4. 10 o'clock in the morning, they received a mail. They looked at the mail. How can he make such an FIR? Para 14.4. A counter affidavit on behalf of respondent number 3 at page 8, para 14.4. It is only after inspector in charge visited times and an email was belatedly sent by one Nishant Kumar, Assistant Director to Commissioner, to inform me that search operation is conducted within the Commissioner jurisdiction. The email has been seen.
So he was seen at 10 a.m.
They had seen it at 10 a.m. and yet they had the audacity to file an FIR after 12 hours. And the inspector in charge is a complainant himself.
How come this was? It was seen at 10 a.m. and
How
yet
could he register in the night at 10
in the
o'clock?
night saying that some officers came in civil and
And it is also forwarded, Malord. This is the affidavit of Director General of Police. And Malord, it is forwarded to the complainant, Malord. Said email was seen, Commissioner, and endorsed to IC Electronic Complex Police and assist Commissioner for taking necessary action. They were ex-face bogus complaint, on the face on their admissions, their affidavits. This is one of the I'll come to this is one of the reasons why they should not be allowed to investigate these offences. Also, this is one of the reasons. This is one of the reasons why I will not get justice in my FIR. Therefore, the FIR is required to be registered not by the local police.
and when this affidavit is by
Director General of Police.
DGP.
Yes.
DGP says that they have seen the.
Yes, at 10 o'clock in the morning and at 8 o'clock they say, contrary to the mail.
And yet they register an FIR at the behest of the Honorable CM.
Yes.
At 12 noon.
Yes.
And then he accompanies with.
Yes, he accompanies. It says on affidavit. Then kindly this one also. Now kindly look at FIR number 5 also, similar thing. What time is the FIR registered?
I want to say so many things, but everything is reported. I am refraining myself.
Now kindly look at FIR number 5 also. There is FIR number 5 in the compilation.
12:45 hours.
12:45 hours, but email was received at 10 o'clock.
This is at page?
It's in my compilation, probably page
23.
29.
Page 23 and 24. In this very affidavit, page 23, FIR 5 of 26.
29 and 30. 29 to 33.
29.
Same affidavit.
Same affidavit, affidavit of R3.
Yes. Now look at the gist. Again claiming to be. So they received it at 10 o'clock. 12:45 they filed, registered the FIR. And say somebody claimed to be ED of claimed to be ED. Kindly look at what is stated in the gist.
No, page 28 is FIR number 192.
No, FIR number 5 of 26 is the FIR. This is at page number.
Counter of R3 in criminal petition number 16.
R3 probably it's not there. It's not there in R3. Yes. In additional documents, my lords.
FIR 5 is page 91.
FIR 5 is at page 91 of our additional document.
And in the compilation, it was at
Page 29.
91.
In his counter, it was at page 23.
That is the whole difficulty.
My lord, it's at page 23 of the counter which my lords are referring.
Yes.
23.
In the counter, page 23, but in the compilation of FIR,
Page 91.
page 29.
Page 29.
29.
FIR 5 of 20.
The fact of the matter, it is 12:45. By 10 o'clock, they had seen the mail And how could there be so this is a reason, additional reason apart from the fact that I will not get justice because they are investigating, they would be investigating the serial. That it is demonstrated that even in the FIRs filed against us, the police officers, they have stated false facts, false to their knowledge. What do you see? Now, my lords, I will show two or three judgments as when CBI investigation is warranted. The landmark case is State of West Bengal versus Committee for Protection of Democratic Rights, 2003 SSC 571. Kindly have a look at para 68. The issue was a federal issue, my lord, whether a court can direct investigation. Para 68 and 70 are what I'm referring to of this time. Sub-para 7. The relevant would be para 70. Before parting with the case, we deem it necessary to emphasize that despite the wide powers conferred under Article 32, my lord, sir, in para 70.
Yes.
Before parting with the case, we deem it necessary to emphasize that despite wide powers conferred by Article 32 and 223 of the Constitution, while passing any order, the court must bear in mind certain self-imposed limitations on exercise of these constitutional powers. Very plenitude of the power under said article requires great caution in its exercise insofar as question of issuing a directive to CBI to conduct investigation in a case is concerned, although no inflexible guidelines can be laid down to decide whether or not such power to be exercised. But time and again, the related such power is not to be as a matter of routine. Extra must be exercised specific exception. This is an exceptional situation where it becomes necessary to provide credibility and instill confidence in the investigation, or where the incident may have national and international ramifications, or where such an order may be necessary for doing complete justice and enforcing fundamental rights. Otherwise, CBI will be flooded with large number of cases, limited resource. Then my lords may have kindly have a look, my lord. Can kindly come to my lord K.V. Rajendran's case, which is directly on the issue, my lords. Para 17. So that it is covered by that exception which is later.
Which matter?
Page 768.
Page?
It starts at page 768, relevant is 776. In view of the above, it's at the bottom of the page 7.
1 minute, 1 minute.
I just need it.
K.V. Rajendra.
Yes. In view of the above, the law can be summarized to the effect. My lord, you got it?
Yes.
Yes. My lord, this Anjari has got it.
Yes.
In view of the above, the law can be summarized to the effect that the court could exercise its constitutional powers for transferring an investigation from state investigating agencies to any other independent investigating agency like CBI, only in rare and exceptional cases such as where high officials of the state authorities are involved. And the accusation itself is against top officials of the investigating agency. My lord, there can't be any top officials than the CM and the Home Minister, thereby allowing them to influence the investigation. And further, that is so necessary to do justice and to instill confidence in the investigation, or where the investigation is primarily found to be tainted and biased. I have demonstrated tainted and biased because of the discrepancies in the timings, and despite knowing they were not only tainted, top functionaries are involved. There was fit case for giving the investigation to CBI. Now, my lord, I'll come to the other aspect. That why the other 4 FIRs are required to be transferred to the CBI. This is a case for registering my FIR and investigating the CBI. Have made out a case. Those 4 FIRs, I've demonstrated that those 4 FIRs are tainted and there are the wrong statement, they're falsely recorded, one reason. But second, my lord, they are cross FIRs. Same incident, 2 versions. The law is that where there are cross FIRs, it has to be investigated by the same investigating agency. Same, it has to be tried by the same court. Of course, decision of one should be followed. It cannot be tried as a joint trial, but separate trials, one after the other. 2 or 3 judgments in this regard, my lord, which on this submission. This is that. I don't know. Karnataka is my lords, may first have a look at this judgment, which is there in my compilation, my lords. Page 766. It's a recent judgment. This Honorable Court, my lords. 2025 SSC Online SC 983. It starts at 751. The relevant para is para 42 at 766. And the heading is cross FIRs are required to be holistically investigated.
Punit very well.
What is that?
This 2025 SCC Online.
SCC Online
983.
983. SCC Online SC 983. That starts at page 751. And my lords may kindly have a look at para 42 onwards. Cross FIRs are required to be holistically investigated. The accused persons have taken various inherently and contradictory stands with respect to the transaction with the appellant. On 23rd July 2020, Bhai Manjit Singh and Bhai Manjit Singh HU have denied the existence of the agreement to sell. On 22nd September 22, Bhai Manjit Singh and Bhai stated that the advance consideration has been returned to the appellant and that they accept that Bhai Manjit Singh, no other person from the HU had met the appellant. Finally, after the registration of subject FIR dated so Bhai Manjit Singh and Bhai Manjit HU have registered an FIR dated 22nd August, alleging that the receipts of payment in favor of the appellant laid upon him in his civil suit as well as FIR dated so fraudulent fabricated. Keeping in view the contradictory defenses of the accused as well as the registration of pendency of cross FIR, this court is of the view that the learned single judge should have limited the scope of investment. In this context of cross cases, Nathilal is a classic case as far as cross cases are concerned. We think that fair procedure to adopt in a matter like the present where there are cross cases to direct the same learned judge must try both the cross cases one after the other. After the recording the evidence in one case is complete, he must hear the arguments, but he must reserve the judge. Thereafter, he must proceed to hear the cross case, and after recording all the evidence, he must hear the argument, but reserve the judgment in that case. The same learned judge must thereafter dispose of the matters by two separate judgments, deciding each of the cases for the evidence recorded in particular case. Evidence recorded in the cross case cannot be looked into, nor can the judge be instructed by whatever is argued in the cross case. Each case must be decided on the basis of the evidence which has been placed on record in that particular case, without being influenced in the same any manner by the evidence or arguments urged in the cross case. Both the judgments must be pronounced by the learned judge. Even though the above decision was rendered in respect of trial of cross cases, the court is of the opinion that in cases involving cross FIRs, it was prudent and fair if the investigation was carried out in a comprehensive manner.
No, but
after the object of the investigation
is there any statutory provision?
There is no statutory. There is
that both the FIRs provision are there for trial of cross cases by one judge.
Yes, but one judge, my lord,
at the investigation stage, that both the cross FIRs should be investigated by the one IO or the same IO. Is there any statutory provision?
There is no statutory provision. There is no statutory provision even for being tried by the same court. There is no statutory provision.
No, but
interest of justice. Now kindly have a look. Karnataka judgment, that full bench judgment of the Karnataka Highcourt division bench. Kindly have a look at this. But same court, unless it can go to the same court if the investigation report is filed in the same court. If it is filed in two different courts, therefore it envisages that the investigation must be conducted by same investigating officer or the same investigator.
No, what in this case, this Punit case, para 45.
Yes, my lord.
Page 767 of your compilation.
Yes, my lord. Our lords are right to that extent, but holistically investigated means they have to be investigated by one agency. How can it be holistically investigated? By different investigating agencies giving different findings on the same point. Same thing will apply to the.
I'm referring to something in your favor.
Yes,
it's not that.
I'm so sorry.
Don't take always that quote is. 45 it says that even if there is no provision, impliedly, even though the above decision was rendered in the respect of trial of cross cases, this court is of the opinion that in cases involving cross FIR, it would be prudent and fair if the investigation was carried out in a comprehensive manner. After all, the investigation to find out the truth. Yes.
Now, the Karnataka High Court Free Judges bench, it is headed by Justice Santana Gowder as his lordship then was. Kindly have a look at para 17. At page 542 of the Indian law reports.
Page, same compilation?
No, I've just handed it. I just handed it separately.
Yes.
Kindly have a look at page 542, para 17.
542.
542.
Yes.
Para 16. Para 16. I'm sorry. To sum up the procedure, my lord, go to para 16.
Yes, that is at 541.
541.
Yes.
To sum up the procedure to be adopted in case and counter case is that investigation should be conducted by the same investigating officer and the prosecution should be conducted by two different public prosecutors. The trial should be conducted by the same court. After recording the evidence and hearing the argument, the judgment should be reserved in one case and thereafter. So this follows Nathilal. But as far as investigation is concerned, it has to be conducted by the same investigating officer. The principle seems to be that if there are two different investigating officers, they may come to two different conclusions, which would unnecessarily complicate the issue. Therefore, one investigating officer, two different prosecutors, same judge, trial one after the other. That's the principle, that's the law. Therefore, if that law is to be applied, then if this case
It is like claim and counterclaim.
Claim and counterclaim
In civil law.
Right. Therefore, if my case warrants a CBI investigation, the others must follow suit. Therefore,
And if your is dismissed, then everything.
even then, the others warrant. The others will warrant, then mine will follow. It will be the reverse case. Supposing, my lord, my case, my lords may not consider at this stage, but if my lord considers the 4 FIRs and feels because of manipulation is required to be investigated by CBI, then mine will follow suit because of cross cases. So it will be a reverse case.
Because you have not prayed for crossing of the FIR against you.
Because we did not have a copy. We sought for a transfer because we didn't have a copy. We didn't know what it was. It was only after we filed the petition that we got the copies. So this is as far as, now kindly have a look, my lord, as far as violation of the petitioner's fundamental rights are concerned.
But
there are 3 types of rights.
But there is no prayer that transfer the FIR against you to the CBI.
There is.
Let us see. Yes, it is there.
I read.
It is D. So, clause D in your petition.
In both.
Page 46.
There are 2 types of cases, essentially. Though there are 3 types of cases, but there are 2 types of cases as far as violation of rights are concerned. I'm not using the word violation of fundamental rights. I'm deliberately using the term violation of rights. Because whether a corporation has a right or not is debatable. My learned friend has addressed my lords on that now. But there can be a case where there is violation of a right of a corporation or an entity. And there is no violation of an individual, whether he's a shareholder or a director, there's no violation of a right of individual. That is case number 1, scenario number 1. Scenario number 2 is there's violation of a right of an individual, no violation of a right of a corporation, yet a petition is filed in the name of a corporation and individual. That is the scenario number 2. Scenario number 3 is an overlap, which is essentially be part of scenario number 2 because there is some right of the individual. Now, all those cases which have been cited, they were cases were essentially under 19. 19 doesn't apply to non-citizens. Admittedly, corporations are not citizens, therefore, right under 19 is not available to them. But what was infringed or what was violated was right of the corporation, not of individuals. Therefore, in that context, the judgments have laid down that individuals, even if they're director or they are shareholders, they can't approach because their rights were not infringed. It was the right of the corporation that was infringed. That was kept open. Kindly have a look at para 46, page 49, my lords, of my lord's compilation. That question has been left open. This is it, Calcutta.
Which compilation?
Compilation is other.
I'll buy this one number 3.
Page?
Now, my lords will kindly first have a look at the facts. Then I'll take my lords to
which judgment?
This is STC judgment.
STC. First item.
Facts.
Yes.
Now, kindly have a look, hello. Page 49. After
page 49 in your compilation.
Page 49 of the compilation given by them.
Given by them. Yes.
And the judgment starts, my lord, at page 1.
Yes.
I'll take my lord first to 14, then go back to page 1.
49, yes.
And after the quoted portion of whether the state corporation is not received, then we are not at this stage. My lord, the sentence starts like, we are not at this stage concerned to deal with any right with the second petitioner KB Lalli may have to maintain the petition. For the question deal only with the right of the company to set up protection under 19(1)(f) and G. So what your lordships are considering is the right of the company, violation of 19(1)(f) and G of the company, not of the individual. That, my lords, will now have a look at pages 1 and 2. This position declared. Why the two petitions, my lord? The three petitions which are there. Page 1, my lord, where the judgment starts. So this honorable court is not considering the rights of individuals, persons. But in my case, the petition, we are saying individual rights are affected. Therefore, these judgments will have no application. Apart from that, 19 is not claimed. In my petition, there is no corporation, there is no ED.
No, but the argument is that you are ED.
I'm not. I'm said in the beginning that I am an officer of, incidentally, I happen to be an officer of the ED. But the offense is committed against me in my individual capacity. Incidentally, I happen to be an officer of the ED.
The argument seems to be you have no independent existence.
There can't be my independent existence.
If the cloak of ED is removed from you, you are nobody
That
in
can't
this
be.
particular litigation.
It is not. Look at the
So
nature.
therefore, the veil is to be lifted. That is the argument.
When I'm restrained, when I'm confined, where is the ED? ED is not being confined. I am being confined. I am being confined. I am being restrained. When hurt is caused to me, when force.
ED is not restrained.
Therefore,
according to you, ED is not confined.
it is not.
You are confined.
I am confined. Therefore, I've come here.
That is your subject.
Yes. Therefore, my fundamental right is violated. When I have been. In the offense which is alleged is against an individual, irrespective of what clothes he dons. He may wear a cloak of ED, exercise immaterial. The offense is against the individual. And that individual has come before my lords, claiming that his fundamental rights are infringed.
Yeah. You were at the same page with Mr. Mehta. You were at the same page with Mr. Mehta.
Yes, I'm at the same page as far as this is my submission. I can't be at a different page.
No. In Mr. Mehta's case, this petitioner number 2 also says the same thing.
Yes.
That he is not
Official capacity and individual capacity cannot be divorced. Otherwise, the moment I acquire an official capacity, I would cease to enjoy fundamental rights in that capacity.
Yes.
Suppose the district judge, honorable district judge, is departmentally proceeded for having done something as a judge of the court. But would he, I'm putting a question to myself, not entitled to his fundamental rights, that I was arbitrarily treated? There was discrimination. One person was not suspended, I am suspended. But then, if this is the logic, which is a correct logic, then he will have no remedy under fundamental right. Then he will have to file suit for damages or whatever other remedy which may be there.
Because court can't avail for
And my lord, in a case like this, as my learned senior colleague said, there is no 19 involved. So the issue of being a citizen or not citizen is irrelevant as far as the facts of this case. But in any case, I am not pitching my case. I am not piggybacking my case as if it is the ED against whom the offence has been committed. No, my case is the offence has been committed against me. Therefore, the appropriate action is required to be taken. That's my case. But I had stated as far as Article 21 is concerned. Now my submissions as far as Article 14 is concerned. My first submission is this.
In that, sorry, I'm disrupting you. When Mr. Prasad Mehta was arguing, one judgment he referred where the Union of India's 32 petition has been entertained. Which was that judgment? Some judgment you referred. Mr. Mehta, you have referred some judgment.
Page 11 or 12 of my written submission, I just heard. The page 14.
Yes, 2016, volume 7 SCC.
Yes.
Page 1. This is what you have referred.
In
your written submission, you have referred.
Yes.
Whether that question is decided.
No, but the court says that in this fact, it would be impossible for. Let me read para 5 what is quoted.
Yes.
Consider the objections raised on ground of maintainability, having heard the respective counsel on the same question, and having regard to the nature of issues which have been referred for consideration by the Constitution Bench, as rightly contended by the learned Solicitor General, we are also convinced that answer to those questions would involve substantial questions of law as to interpretation of Article so and so, as well as corresponding provisions of the Penal Code and the CRPC, and thereby serious public interest would arise for consideration, and therefore we do not find it appropriate to reject the reference on the narrow technical ground of maintainability. Certain questions come before your Lordship, which requires your Lordship to examine those questions, like the present one, in my service.
If apart from my right to move, my learned contention is that he has an independent right, divorce my right, and one of the petitions.
But it is that V. Sriharan case, that jail inmates case, that question about sentence.
Yes.
Meaning of life imprisonment.
Yeah. That's the one. ED may have an independent right.
Lord, I must, Lord, I'm sorry, with permission of my learned friend and my Lord's permission. Lord, state governments have also approached this Honorable Court under Article 226. I'm sorry, under Article 32. Lord, if your Lordships have my written submissions, I missed that part, Lord. I just, Lord, I would like, Lord, my. It was entertained and disposed of. Page 24 of my written submission. Lord, I'm sorry, Lord, for a little digression. State governments, including the state of West Bengal, have approached this Honorable Court. Please have a look. By way of read under Article 32 of the Constitution, and this Honorable Court has been pleased to entertain such writs. Then kindly see, it is submitted that in the then para 47, reliance is placed on the judgment of this Honorable Court in state of Tamil Nadu versus Government of Tamil Nadu. Well, that is the governor's power. The state was in a petition. One of the questions raised was whether 32 lies at the behest of the state government. And of course, on merits, the view is now different, because of the reference to the Constitution. My lord, next page 25, State of Orissa versus Government of Orissa. Clearly 131 case. Kindly see, my lord, the prayer spray. But 32 is entertained. The State of Orissa versus Government of India, wherein a petition under Article 32 filed by the State of Orissa was allowed by this Honorable Court. Relevant findings are as under. The State of Orissa has filed this petition under Article 32 of the Constitution, wherein the Government of India has been made respondent number 1 and State of Andhra Pradesh has been made respondent number 2. Inter alia for the following relief. Direct the Government of India to constitute an appropriate tribunal under Section 4 of Interstate Water Disputes Act and thereafter refer to it, the dispute relating to construction of side channel here and flood so and so. A classic 131 case. Dispute between two states and union. Then para 2. As indicated in the very opening paragraph, the writ petition was filed by the state for a direction to the central government to constitute a water dispute tribunal under the Interstate Water Disputes Act and to refer the tribunal the said dispute, etc., etc. Then the court allows the writ petition, saying that the people's right under Article 21 is violated. But other judgments also we have cited where the states have invoked your lordship 32. And my lord, para 49. It is submitted that even the state of West Bengal has approached this honorable court in past by way of a writ petition under Article 32. The reference in this regard is made to the case of state of West Bengal versus Secretary to the Governor of West Bengal in writ petition number so-and-so, which is a petition under Article 32 of the state of West Bengal, which the honorable court was pleased to entertain and issue notice. My lord, we have placed that on record at page 600. Page 600, my lord,
600
of this compilation. Our compilation. The state cannot take a contradictory text. Files a petition and says that others cannot file.
So 600 is copy of the petition, not the order.
No, order is at 624 is the order, notice is issued. The earlier dispute, my lord, governor, etc. But the point is, as a petitioner, do the state also have the locus? Well, here, my lord, individual is also before your lordship. That is the submission.
Dr. Singhi argued that case.
Yes, my lord, the state of Tamil Nadu was argued by my learned senior and my lord, Dr.
That is the benefit available
The
to
lawyers are never bound by the estoppel. None of us bound.
Only judges are bound.
No, my lord, your lordships are not bound by it. But 32 constitutional powers are not bound by anyone except your lordship's self-imposed restrictions. My lord, can you see? Therefore, in constitutional courts parlance, we say that this is a self-imposed restriction, not a jurisdictional bar. Whether it's alternative remedy, estoppel, this, that, and others. These are all constitutional self-imposed restrictions. Because of the high office, Lord, your lordships are holding.
No, but there is inherent danger also. If we keep on entertaining, then this court will be flooded with Article 32 petitions.
It is being flooded, but restrict to individuals. That's
flooded not by individuals, by different state governments.
Lord, as a matter of fact, I must tell your lordships, Lord, very candidly, this was one of the questions referred by the Honorable President of India in that presidential letter. But the 5-judge bench says that we would not take it.
As a court, shall we discourage or shall we encourage?
But it should be discussed.
Discouraged. Then we should dismiss this.
Look, this is not a statement. I'm not on road. Your Lordship asked me as a proposition of law. This is a fact-specific case where individuals are before your Lordship. Here, state of Tamil Nadu filing a petition against the governor of Tamil Nadu. That matter chapter is over. Now it is covered by the 5-judge bench. But your Lordship would decide on fact-specific cases.
Yes. Yes, Mr. Raju. We disturbed you.
I will demonstrate how there is infraction of Article 14. Lords. Violation of my right under Article 14.
Yes, yes.
Lord, any procedure that requires a person to have an offense against him registered and investigated by an investigating agency, which is apparently not going to be fair, impartial, and which is going to be biased, is arbitrary. And arbitrariness strikes at the root of Article 41.
You see, like the petitioners,
yes,
coincidentally being ED officers,
yes,
if they have their individual right,
yes,
as a person, does the CM doesn't have her individual right as a person?
She can come.
I'm not. She is not before my Lordship.
No.
It.
No, for lodging the FIR or all other things.
She can. Nobody has prevented her from lodging an FIR. In fact, she has registered an FIR.
Yes.
But what I'm saying is, I'm not saying. I am saying that the right to lodge an FIR and right to investigation includes the right to lodge it at a place and to have it investigated by an agency which is fair and which does proper investigation and impartial and unbiased investigation. That is the right. If any procedure which takes away this right and which forces you to go to a police station where you know that the investigation is going to be partial, is going to be biased, and is going to be unfair, then that procedure is arbitrary and that would be violative of Article 14. That is my submission. Therefore, the procedure which requires.
She has a right to file a FIR, not get it investigated by officers under.
As my learned friend says, but she has a right to file an FIR, but not get it investigated by persons under her. That is a different thing. But as far as the procedure which requires me to file an FIR under 154, in the facts of the present case, go to the local police station, get it investigated by the local police, knowing fully well that the local police is subordinate, highly subordinate to the accused persons, is an unfair procedure, is an arbitrary procedure, it would violate Article 14. That is my submission as far as Article 14 is concerned. One of the submissions as far as Article 14 is concerned. Now, in this case, this connection, I'm relying on 2 or 3 judges. May I continue tomorrow?
Yes.
Tomorrow is
tomorrow,
miscellaneous. Tuesday, mother.
No, Tuesday, Wednesday, there is a fixed.
Tuesday would be better.
Tuesday, Wednesday, there is a fixed. Both of. Possibly.
So then they agree. Both of you agree.
We'll give a date. We'll give it enough time. We'll agree by which.
Yes.
Can we discuss? No, we will not take the Lordship.
Yes, we'll give a date.
We'll discuss.
We'll discuss
Yes.
and give a convenient.
Arguments continuing. Post on करके छोड़ देना जैसे वो डेट बताएंगे दोनों एग्री डेट.
Okay, no problem.
On top of
I'll take care of.
Interim order maker.
Yes, interim. Thing is going to happen.
Nothing but
But once there is an order, it has to be continued.
Yes, that.
nobody can oppose it. There's no question.
ये सब जोड़ से जाना ठीक है. जो टिक किया है ना मतलब ये written document है.
That's